ಸರ್ ಯಾವ್ದು ಕೇಳ್ತಾ ಇರೋದು ಹೇಳಿ ನೀವು?
Serial number 23.
ಕರೆಕ್ಟ್. ಓನ್ಲಿ ಸರ್
2009-41.
ಕರೆಕ್ಟ್. ಡಿ ನಾರಾಯಣ್ ಸ್ವಾಮಿ ಕರೆಕ್ಟ್. ಓಕೆ, ಡಿ ನಾರಾಯಣ್ ಸ್ವಾಮಿ. ಇದು ನೀವು ಹಾಕಿರೋದಾ?
ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡ್ಸೋಣ ಅಂತ.
ಅಲ್ಲ, ನೀವು ಹಾಕಿರೋದು ಅದು?
ಸರ್ ಕೇಳ್ತಾ ಇದೆಯಾ? ಹಲೋ,
ಕೇಳ್ತಾ ಇದೆ.
ಆಡಿಯೋ ಚೆಕ್ ಮಾಡ್ಕೊಂಡೆ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳ್ತಾ ಇದೆ ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ.
Kindly, my lord. Suit for partition, my lord. Interim order was in 2.5 years, my lord. By interim order, my lord, the IA is dismissed, my lord. I am seeking for not to alienate, my lord. There was an interim order of 2.5 years in the suit.
Yeah.
Suit for partition, my lord.
Where interim order was there?
The trial court, my lord.
Come on.
My lord, changing the name of the plaintiff case of mother and father. So dismiss for non-prosecution nearly up to 3 days. Subsequently filed a miscellaneous petition for restoration. Even the same was dismissed by the same judge, my lord. Now the file is present at the respondent has been served by hand through RPH, my lord. The urgency is that, my lord, he has gotten a job offer, but there's a discrepancy in the name of the parent. Because of that, it will be taken up, my lord.
Yes, sir.
Page number 1, serial number 1 to 4. Page number 2, serial number 5 to 10. Page number 3, serial number 11 to 15. Page number 4, serial number 16 to 22. Page number 5, serial number 23 to 29. Page number 6, serial number 13 to 36. Page number 7, serial number 37 and 38. Page number 8, serial number 39.
39 my lord. One R1 ಗೆ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್
31.
39 my lord.
You are appearing for respondent number 1.
Respondent number 1 my lord.
At the request of counsel for the respondent number 1. Read this matter next week.
Page number 9.
With your lordship kindly,
41.
my lord, with your lordship kindly,
Yes.
with your lordship kindly,
Yes.
my lord, serial number 37 in the second list, my lord.
Yes.
My lord, I have sought for stay, my lord, I got sir. I have
Page number 9. Serial number
I got some inconvenience to
Yes. Yes.
when the case is called to be present.
40 and 21.
Yes.
Page number 10. Serial number 42 to 52.
43, please.
43. Yes.
Respondents counsel not feeling well. They want a week's time.
Yes. At the
See,
request of
Dipper Swami
counsel,
already intimated.
at the request of respondent, read this matter next week. Yes.
Please be covered.
45.
Yes. At the request of counsel for respondent. Next week.
Page number 11. Serial number 53 to 55. Page number 1. Hearing interrogatory application matter. Serial number 1 to 18.
Notice.
Admission matter. Serial number 19 to 50.
Notice.
Serial number 19, my lord, we called along with connected matters. There are 4 connected matters.
ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದ್ಯಾ
ಎಲ್ಲ admission ready.
ಅದಕ್ಕೆ ಇದು ನೋಟಿಸ್ ಆಗ್ಲಿ ಅದು ಬಂದ್ಮೇಲೆ ಅದ್ರ ಜೊತೆಗೆ ಇದನ್ನ ಟ್ಯಾಗ್ ಮಾಡಿ.
Please.
Number 2. Order. Serial number 1. Associate party for opponent. AK Bhatt.
Yes. Non amendment of cost rate. Yes.
1A is dead. 1B and C are LRs. 1A is dead.
No, that non amendment of cost rate in respect of deceased R1.
Steps ಬೇಕಾಗಲ್ಲ.
Steps ಸಿಗಲ್ಲ. amendment.
Carry the amendment.
ಏನು ಅಲೋ ಆಗಿದೆಯಾ ಮೆಮೋ ಹಾಕಿದ್ದ
ನಾನು ಹಾಕಿದ್ದೀನಿ.
ಹಾಕಿದ್ದಾರೆ.
ನೀವ್ ಹಾಕಿದ್ರ then you have to carry out that.
Yes, I'll do it.
1B and C are the LRs of 1 ಅಂತೇಳಿ.
Yes,
One A.
filed in a memo. Respond no more respond to until their legal representation. Memo is accepted. Yes, ಆಗಿದೆ amendment ಮಾಡೋದು.
Carry.
Week's time is granted. Request of counsel for the appellant, week's time is granted to amend that cost rate.
Serial number 2. Ravi S. Sampati for appellant. Connected matter. Okay.
Yes, my lord. I have filed wakalat because I had filed another appeal. So I came to know that this is counter appeal filed by insurance. So I have filed wakalat. So it may be accepted for R1.
No, that notice has not been ordered.
ಇಲ್ಲ ನಮಗೆ ಗೊತ್ತಾಗಿದೆ ನಾವು ನಮ್ಮ ಕೇಸಲ್ಲಿ ಹೌದು.
On the request of London counsel for the appellant, use this matter along with the MFA. ಆಗಿದೆಯಲ್ಲ connected matter.
ಕನೆಕ್ಟ್ ಆಗಿದೆ.
Yes, yes,
So R1 set.
yes. She but has filed in a wakalat for respondent number 1. The same is office is directed to accept the same. Who is for 2 and 3?
2 and 3 ಅವರು ಸಂಪ್ರತಿ ತಗೊಂಡು.
No, Ravi Shankar has Samprati has filed an appeal.
ಹೌದು.
You are appearing for R1.
R1 claimant.
No, who is 2?
2 ನಮ್ಮ ಇವರಲ್ಲ.
Allah, who is 2? Notice agilla. I will issue notice to 2. Permanent notice to respondent number 2.
Well, Shastri and O Mahesh name may be deleted.
ಯಾವ್ದ್ರಲ್ಲಿ ಈ ಶಾಸ್ತ್ರಿ ಇಲ್ಲಲ್ಲ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಆಫೀಸ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ ಶ್ರೀಪಾದ್ ವಿ ಶಾಸ್ತ್ರಿ ಫಾರ್ ಅಪ್ಲೈ. ಓ ಮಹೇಶ್ವರ್ ವಕಾಲತ್ ಹಾಕಿರ್ಬೇಕಾದ್ರಲ್ಲಿ
ಇಲ್ಲ.
ಆರ್ಟು ನೋಡಿ.
ಹೌದಾ?
ಅವ್ರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ಶಾಸ್ತ್ರಿ ನೇಮ್ ಡಿಲೀಟ್.
ಆಮೇಲೆ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಗು. ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದು ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಗು.
ಯಾವ್ದ್ರಲ್ಲಿ
ಟ್ರೈ ಕೊಟ್ಟು
Enhancement having deposited that award amount before the trial court.
Final ಹಾಕಿಲ್ಲ, photo copy ಹಾಕಿಲ್ಲ, ಅದ್ರ acceptance ಇದೆ.
Yes. Learned counsel for the appellant has filed an memo on the acknowledgement having deposited that amount before the trial court. The same is accepted. Yes. Now, who is that respondent number one?
One is owner of the vehicle.
Yes. Week's time is granted to pay the forces, issue notice to respondent number one.
Yes, sir.
Memo for treating R2, R3 as the LRs of R1.
R1. 2 and 3 is the LR sub R1 malad.
Who is that? R1 is that.
Jay Prakash is the advocate is the James malad. I filed along with the death certificate. I accepted the local.
No, that Anjanappa is dead now.
Please.
Jaiprakash for R2. They have filed an wakalat for Manjunath. Anjanappa Gauri Manjunath. Anjanappa Gauri Manjunath. Now Anjanappa is dead.
Anjanappa is dead malad.
Yes.
2 and 3 are the LR sub the
Yes.
Anjanappa malad.
The net counsel for respondent has filed a memo stating that respondent number 1 is dead. Respondent number 2 and 3 are the LRs of deceased respondent number 1. Memo is accepted. Respondent number 2 and 3 are treated as LRs of deceased respondent number 1. The net counsel for the appellant is permitted to amend the constant.
Delay may be controlled.
Yes, there is a delay of 29 days. It is stated in the accompanying affidavit, delay is controlled.
So first for admission tomorrow, next week.
And amendment ಮಾಡಬೇಕಲ್ಲ. Yes, next week.
For third respondent, please. Ready for disposal. Malad, first respondent is dead because the driver vehicle is not necessary. Appeal may be taken as first respondent.
Yes.
Death case, please.
Steps to be taken in respect of R1 since postal sheriff party is death. Government counsel for the appellant has filed a memo. Respondent number 1 is the formal party. Therefore, appeal may be dismissed against that respondent number 1. Memo is taken on record. Appeal against that R1 is dismissed. Yes.
Death of age.
Yes, what is this?
This is 25 years, Malad. He was working as a lecturer in Diksha College, Bangalore. He was earning 20,000. Tribunal has taken 20,000 income, the chemistry lecturer. And he is already satisfied deposit amount. Trial court has failed to award the future prospect, Malad.
Yes. Future prospect is not awarded.
10,000, 40% into 12 into multiplier.
Yes, mister. What is his age?
25 years, Malad.
40%. ಅಷ್ಟೇ ಅದೊಂದೇ ಗ್ರೌಂಡ್
ಅದೊಂದು 10,000 40% into 12 into multiply.
Yes, learned counsel for appellant has contended that in view of judgment of apex court, the claimants are entitled for future prospect in view of judgment of apex court in case of Pranay Sethi. The claimants are entitled for future prospects. The tribunal has failed to grant any compensation under the head of future prospects. It is sought for enhancement of compensation. For contrast, Sri Vinny learned counsel appearing for insurance company has contended that since the claimant has failed to establish their income, the tribunal has rightly not granted any compensation for future prospects. Heard the learned counsel for the parties, Feroz, judgment and award is not in dispute. Mahendra, what is his name of deceased, mister? Deceased. Huh? Naveen Kumar died in road traffic accident occurred on 22/1/2018 due to rash and negligent driving of driver of Bolera,
Submission is unmarried, 50% will be deducted.
tribunal ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ
50%
ಅಷ್ಟೇ ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಒಂದು ಅದರ್ ವಿ ನೀಡ್ ನಾಟ್ ಮಿಸ್ಟೇಕ್. Bolera bearing registration number KA04 MK 9511. The only contention which is raised by the appellant that in view of judgment of apex court in case of Pranay Sethi, the future prospect has not been awarded. If the tribunal has assessed the monthly income of the deceased as 20,000 in view of judgment of apex court in case of Pranay Sethi, the deceased was aged about 25 years. 40% of the income of the deceased has to be added for future prospects. Deceased was in a bachelor. Tribunal has rightly deducted 50% of the income of the deceased for personal expenses. The particular applicable to that age group is 18. Accordingly, loss of dependency has been reassessed as follows.
20,000 plus 8,000, at a 40%, 28,000, minus 14,000, at a 50%, 14,000, 14,000 into 12 into 18, 2 lakhs 24,000.
Yes. The compensation awarded by the tribunal in the other hand.
The same is against the awarded by the tribunal. Total amount is as against the 22 lakhs 40.
How the loss of dependency reassessed us in respect of other hand. Compensation awarded by the tribunal is just and reasonable.
Number 6, ethics due for appellant, just Indraj.
Yes. Yes, Mr. 6 weeks time is granted to do the needful.
Number 7, every Sampati for appellant, 100 matter, Soumya.
Yes. You take notice in connected matters. India Insurance Company is appearing. Yes. Naturally, effect traveling. Who is this?
My lord, is it the second list, my lord?
Yes, yes, yes.
With your lordship's kind leave.
Raju.
It is 7th matter, sir.
No, second list, Allah. Second list or first list?
Second list, sir, second list.
Please, please. Much obliged.
Connected matter, please. First matter, right? Yes, sir.
India versus Siddharaju Narayana Gupta.
Narayan Gupta Jarotal. Notice of that. First matter, week's time is granted. Pay the process, issue notice to R2. Second matter, Ravi Samprati directed to take notice for respondent number 2. Issue emergent notice to respondent number 1. Yes.
They are
Yes, Mr. Swami, permission with regarding the topic of just.
number 8 is Mr. Swami, they are
Possible.
number 9, Nagaraj.
An application for amendment of claim petition and also for annulment of delay.
Notice.
Number 10, then people for appellant, chair is one appellant.
Yes, week's time is granted to do the needful.
My lord, one submission, my lord. Serial number 10, my lord.
Yes.
Number 10,
Yes.
My lord, in this case, my lord, serial number 10, 1, 10.
It's 10.1,
Lord.
what is it? Yes.
Serial
Mr.
number 10 and 10.2 is one matter. And serial number 10.1 is a different matter, my lord. That is no way connected with the serial number 10 and 10.2.
Yes, yes, we'll verify.
My lord, I'm sorry.
Yes, we'll verify. Yeah,
My lord, one submission. Serial number 10
Yes, Mr. We understand.
and serial number 10.2 are both are connected matter. Serial number 10.1 is not a connected matter. That is a different matter. That matter is connected with the MFA 4831/22. That may be separated, my lord.
4355 connect ಮಾಡಕ್ಕೆಲ್ಲ ಅದ್ರ ಆಗಿದ್ದಾರೆ. 4355 connect ಮಾಡಕ್ ಆದ್ರೆ ಗೊತ್ತಾಯ್ತು 4355 where is that order for connecting that appeal?
Please.
4355 Yes.
4355 is a BMTC matter.
Yes. Office is directed to delete the 4355 of 2022.
My lord,
Appeal 5337 of 2022. Yes.
my lord, in this, my lord, stay is granted, but the amount is not deposited before the trial court.
Let the matter be
I'm for
connected with the
responding.
MFA. Which matter?
Serial number 11.
That is not 11. No, 11 is not called.
In which matter to raise that object? Yes. Quite well, please.
I am for the applicant, it is with regard to the name mentioned in the cast title. I have mentioned Madhuvapati as per the award. Cast title mentioned in the award melody. That is page number 37. ಅದರಲ್ಲಿ ಇವ್ರ ಪ್ರಕಾರ ಇವ್ ತೆಗ್ದಾಕಿ WA ಉಳಿಸ್ಕೊಡ್ತೀನಿ ಸಾವಿರದಿಂದ ಮಧುವಾಪತಿ ಅಂತ ಆಗ್ಬೇಕು. ಅವಾರ್ಡ್ ಪ್ರಕಾರ ಬರ್ದಿದ್ದೀನಿ ನಾನು ಮಧುವಾಪತಿ ಅಂತ. That's only the Wapati. The same has been mentioned in the cast title.
ಎಲ್ಲಿ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಏನಿದೆ?
ಅದೇ ಮಧುವಾಪತಿ ಅಂತಿದೆ.
ಹೌದು, ನೀವು ಅಂತ ಹಾಕಿದ್ರಲ್ಲ,
ಅಷ್ಟೇ ಹಾಕಿದ್ದೀನಿ. ಅವ್ರ ಪ್ರಕಾರ ಯು ಬರಬಾರ್ದು, ಮಧುವಾಪತಿ ಬರ್ಬೇಕು ಅವ್ರ ಪ್ರಕಾರ.
ಯು ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ನನ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ
there is no you.
MADHU.
MADH.
ಯು.
You ಇಲ್ಲಲ್ಲ?
ಇರೋದು ನೇಮ್ ಆಫ್ ದ ಪಾರ್ಟಿ ಡಸ್ ನಾಟ್ ಟ್ಯಾಲಿ ವಿತ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿ ಅಂತ ಸರ್.
ಯಾರು differ from judgment and award. ಅವಾರ್ಡ್ ಮತ್ತೆ ಇದರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಇದೆ ಅಂತಾರೆ. ಅವಾರ್ಡ್
ಪೇಜ್ ನಂಬರ್ 37.
ಮಧುವಾಪತಿ ಅವಾರ್ಡ್. ಇದರಲ್ಲಿ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಯು ಮಾಡಿದ್ದಾರೆ.
ಮಧುವಾಪತಿ
ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಎಸ್,
ಕೆಲವು ಕಡೆ ಮಧುವಾಪತಿ ಈವನ್ ಇನ್ ಕಾಸ್ಟ್
we have to remove this computer system itself because of all this.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ
Nobody will see what is that order and all. Everybody is typing and
KSRTC appeal ಇದರಲ್ಲಿ stay application.
ಅದರಲ್ಲಿ ಯಾರ ತಂದೆ, ಯಾರ ತಾಯಿ, ಯಾರ ಹೆಸರು,
father name is mentioned correctly.
mixing everything there. What is this matter? Submission of learned counsel for the appellant is accepted. Office objection is overruled.
I will deposit 50%. ಇದರಲ್ಲಿ claim for the damages of the car. ಅದರಲ್ಲಿ 3 lakh. ಅದರಲ್ಲಿ they have already claimed.
ಎಷ್ಟು ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ?
ಇದರಲ್ಲಿ 3,76,268 ಮಾಡಿದ್ದಾರೆ. They have already claimed damages from some other insurance company.
No, this is only against that one MEC.
One MEC.
ಯಾವುದು MEC?
MEC 416. 416.
Yes, heard. Issue notice.
50%.
Stay of judgment and award dated 20th April 2022. Passed by MACT. Report in MEC 416 of 2021 subject to applying depositing 50% of the award amount with interest before the tribunal. within
Trial
4
court.
Serial number 12, Aadhaar gateway.
of conversion.
WP.
Next, counsel for the appellant has filed a memo. Leave of this court to convert this appeal into writ petition. The memo dated 10/2/2023 is taken on record. Learned counsel for the appellant is permitted to convert this appeal into the writ petition.
Serial number 30, Nangakoda Enhancement appellant, be present.
Yes, Nangakoda, what is ready?
Case of injury. The date of accident is 15/11/2020. The appellant has sustained a stab of fracture of left hip, auto amputation of fourth and fifth left toes, and other injuries. BW2 doctor has assessed the disability.
Whole body 24%.
Please.
Tribunal ಎಷ್ಟಾಗಿದ್ದಾರೆ?
Tribunal, my lord, only 15% has been considered. 44% to the whole body. My lord, left lower limb disability assessed, my lord, 72%. Tribunal, my lord, only 15% has been. Other communities, my lord, 30,000 has been. Patient for a period of 10 days, my lord. Patient.
Yes, sir.
10 days in patient.
Yes.
Minute suffering 18,000 has been.
Income,
Income, my lord.
Correctly, sir. 14,500.
14,500 correct.
That's correct time.
Minute suffering ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of immunities. Other discharges 27,000. Medical expenses. Loss of income during the later.
Well, future medical expenses, my lord, no amount has been granted.
What is that doctor said?
Doctor said, my lord, the evidence, my lord, assessed removal of implants and total.
ಏನ್ ಸರ್ಜರಿ ಆಗಿದೆಯಾ? This is a petition now complaint to what?
What can be granted, my lord?
ಎಷ್ಟಂತ ಹೇಳಿಲ್ವಲ್ಲ?
ಹೇಳಿದ್ದಾರೆ.
Surgery for removal of the implant and total
Hip replacement.
estimated is surgery around rupees 4 lakhs. What is that reason for 4 lakhs? Implant removing. Yes.
Total hip replacement of it.
Yes.
Data period, my lord, only 43,500 has been.
Correct ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ?
3 months correct ಆಗಿ ಕೊಡೋದು.
What is that interest?
Interest, my lord,
6%.
6% has granted.
Yes, that's all.
Disability ಅಲ್ಲಿ 20% may be taken.
Doctor said 24%.
Please, my lord.
Yes. ಅದು 75% ಇದಿದೆಯಲ್ಲ?
Amputation.
Amputation ಇದೆಯಾ?
Amputation of
Amputation ಆಗಿಲ್ಲ.
ಇದೆ ಮೇಡಮ್.
ಎಲ್ಲಿದೆ?
Evidence ಅಲ್ಲಿ ಇದೆ.
No, it is not amputation.
Amputation of the fourth and Fifth left to toss.
Toss.
Out.
Toss ಗೆ ಅಷ್ಟೇ ಬರೋದು 25% ಬರೋದು. Fine. So and so learned counsel appearing for the claimant has contended that due to the accident, claimant has suffered serious injury, was inpatient for a period of 10 days. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered permanent disability to left lower limb to the extent of 72%. 24% to that whole body. The tribunal has assessed whole body disabilities, 15% is on lower side. Further contended that due to that extent, claimant has suffered grievous injury. Yes. Yes, he was inpatient for a period of 10 days. He has suffered lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Lastly, he has contended that due to the extent, claimant has suffered a grievous injury. He has undergone surgery. Doctor has deposed that he requires 4 lakhs rupees for removal of implant and further surgery. Tribunal has not granted any compensation for future medical expenses. For contra, V. Pradeep, Mallikarjun Reddy, learned counsel appearing for V. Pradeep, submitted that even though doctor has deposed that the claimant has suffered 72% disability to left lower limb and 24% to whole body, considering that injury suffered by the claimant, considering his age and avocation, tribunal has rightly assessed whole body disabilities 50%. Other contended that considering that the evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is felt reasonable. Lastly, he has contended that even though doctor has deposed that the claimant required 4 lakhs rupees for either medical expenses for removal of the implant, he has not produced any estimation. Therefore, tribunal has rightly not granted any compensation under the head. And he sought for this of the appeal. Or the learned counsel for the parties. Rules. Yes. And award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 15/11/2020 due to rash and negligent driving of driver of goods auto bearing registration number KA04B4632. Due to the accident, claimant has suffered the following injury. Was inpatient for a period of 10 days. Doctor has been examined as PW2. In his evidence, he has deposed that claimant has suffered permanent disability to the left lower limb to the extent of 72%, and the whole body is 24%. The claimant also undergone amputation of his left toe. Left toe. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities can be assessed 24%. The tribunal has rightly assessed income of the deceased as the income of the claimant as 14,500. Multiplier applicable to the age group as to what is his age?
47 years.
47 is 13. Accordingly, loss of future earning has been reassessed as follows. 13,500
20 into 24%. Wetlands 42,880.
Due to the tax claim, claimant has suffered the opposite injury. You are inpatient for a period of 10 days. Considering that evidence of doctor and injury suffered by the claimant, the compensation awarded with the tribunal pain and suffering, loss of immunities, other incidental expenses is just and reasonable. The claimant is entitled loss of income during the later period for other 3 months. 3 months awarded under the head is just and reasonable. In respect of future medical expenses is concerned, the claimant has examined the Dr. Nagraj BN as PW2. In his evidence, he has deposed that claimant required another surgery for removal of the implant and total hip replacement estimated of this surgery is around 4 lakhs. No document has been produced. They have not produced that estimation. Considering that nature of the injury and considering that medical records, I am of the opinion that the future medical expenses 25,000 can be awarded. Yes.
There has been about 6% interest.
6 iradu.
Please, my lord.
Serial number 14, Kumar against for appellant.
Since the value of the appeal is less than 1 lakh.
Dismiss agreed. Claim petition was dismissed, my lords. The claim was 85,000. Claim petition was dismissed, my lords. It's maintainable.
Now 1 lakh ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಲ್ಲಿದೆ?
173 ಕೆಳಗಡೆ 1 lakh ಒಳಗಡೆ ಇದ್ರೆ ಹಾಕಂಗಿಲ್ಲ ಅಂತ ಇದೆ.
ಅಲ್ಲ ಸರಿ 1 lakh ಅಂತ from where that officers get that it is 1 lakh.
173 ಕ್ಲಾಸ್ ಕೆಳಗಡೆ 1 lakh ಇಂದ ಒಳಗಡೆ ಇದ್ರೆ
ಅಲ್ರಿ ನಿಮ್ claim petitioner what is the claim?
85,000.
Huh?
85,000.
85,000. Then it is less than 1 lakh.
ಹೌದು but my lords, it was dismissed. The petition was dismissed. It is not enhancement. They are not seeking for enhancement. Claim petition was dismissed.
Then that appeal has to be filed. But what is that section says 173?
Less than 1 lakh ಇದ್ರೆ appeal maintainable ಆಗಲ್ಲ.
Yes, subject to the provisions of subsection. Yes. Office objection in respect of mental is kept up on issue notice.
Is permitted to withdraw.
Yes, Government Council for the appellant has filed a memo seeking leave of this court to withdraw this appeal.
Please.
Yes.
Number 16, as value for appellant.
Yes.
Claiming the compensation of 5 lakh rupees for the trial court. The rest of the amount, value the rest of the amount already 4,30,000 has been awarded by the tribunal balance. Rest of the amount value because the value is increased. Rest of the amount value the field amount.
Now, what is that claim?
Claim 5 lakhs.
5 lakhs.
5 lakhs.
4,30,000 ಕೊಟ್ಟಿದ್ದಾರೆ. In remaining is less than 1 lakh.
1 lakh. ಅಲ್ಲ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡೋಕೆ ನಾನು ಮಾಡಿದ್ದೀನಿ. ಒರಿಜಿನಲಿ ಕ್ಲೈಮ್ 5 lakhs.
Now that your appeal is only in respect of that less than 1 lakh. Therefore, they said it is not maintainable. See, you claimed 5 lakhs. Now that 4,30,000 has been granted. In 70,000, you have to file a writ petition. The appeal is not maintainable. If it is ultimately, if it is appeal has to be decided if it is more than 1 lakh. That is what that office objection. Yes.
After next week, exactly.
Yes, next week.
Number 20, Jay Kumar Prakash.
Potential that statutory deposit has not been made. Rate has been paid, but not, it is not there today.
Yes. And the request of council for the appellant, please this matter of 2 weeks.
Number 18, Yasin Rao.
On deposit the interest part. Yes. Now that in the ECA matter, it is mandatory that first you have to deposit, then court has to entertain. Yeah, interest you deposit next week we will have it. Yes. Appeal is maintainable only after depositing. Yes. It is matter next week.
Number 19, Hanuman Reddy.
I am for reference, my lord.
Yes.
This matter, my lord, there is an office objection raised with respect to the limitation. What happened in this matter, my lord's copy application was filed prior to the date of judgment, my lord. By mistakenly, and it was not rejected, and we got the certified copy after the judgment was released. So that period, office has raised an objection. I have submitted my.
No, what is that you said? What is that limitation?
Limitation is correct, my lord. What happened is that prior to judgment happened to apply for the certified copy. That was the only objection raised. But certified copy was received.
Copy
there is no
on
delay in fact.
No, when that application required to be appeared on 8/6.
Yes, so
Applicant appeared on so and so. When that judgment has been this thing?
judgment has been passed on
2nd May 2023.
Yes, my lord.
When you have filed an application?
Application was submitted on 20th 18th for my lord. That was the day when it was posted for judgment.
No, how can you find
No, by mistakenly happened, my lord.
Yes.
As
Then when that judgment has been
it is received on
applications appeared on so and so.
appeared on
Copy ready on
25/5 we received the certified copy.
25/5/2023.
Yes, my lord.
When you have filed?
Filed on 17/8/2023 within time. 17/8/2023
5 to 6, 7, 8, 17 markidira.
Yes.
Yes.
Within time, my lord.
Yes. Learned counsel for the appellant. Adonde office objection, huh?
That is the only office objection raised. In the connected matter, my lord, yesterday the lordship was pleased to grant, and this is the national highways matter where contributory negligence was attributed.
Yes.
And it is in fact the maximum.
The office objection in respect of serial number is office objection in respect of limitation. Submission of the learned counsel for the appellant is accepted. Office objection is overruled.
Right.
Yes. What is that yesterday's
Order.
What is that order we have passed?
Stay of interim order insofar as appellant is concerned, my lord.
Yes. 50% is your liability.
50% is my liability.
Yes,
In fact, there was no jurisdiction for the tribunal to pass any order again.
Issue notice. Okay. Learned counsel for the appellant. It will delay lala.
No delay, my lord.
What they passed by the so and so is in respect of the liability related to the appellant is concerned.
It posted along with
Yes, on this matter along with that. Okay, so and so. Okay, 577 9 of 2020.
grateful, my lord.
Number 20, Renee Gurana for appellant, ready.
R1 and R2 dispense ready.
Very much. Only rate of interest will be there. Easy event.
I think my lord, was the interest component that I am my lord when considering the granted the award of granted lord interest
12% ಮಾಡಬೇಕಿತ್ತ
6% from the date of market instead of 12% 1 month from the date of market.
No, 6% to 12% from the date of the accident.
1 month from the date of market.
1 month from the date of the accident. That has to be modified.
Only interest.
Yeah. Which is that provision?
One.
Huh?
Forward season.
Third. The substantial question of law arises for consideration whether tribunal is justifying according the 6% Employees Compensation Act. It requires to be awarded interest is 12%. We of service. T. For one. T number. Because of the injury specified. What are the good things? What are the other points? What shall learned counsel appearing for? Limit has contended that in view of provisions of in view of so and so provision of the Employees Compensation Act, claimants are entitled 12% interest 1 month from the date of the accident. The tribunal has awarded 6% interest. Therefore, the same is contrary to the provisions of Employees Compensation Act. He is sought for enhancement of compensation. He brief Pradeep learned counsel appearing for insurance company has not disputed about legal position. Heard the learned counsel for the parties. Following substantial question of law has been arises for consideration. It is not in dispute. Claimant was not in dispute regarding the relationship of the employer and the employee between the claimants and respondent number 1. It also not in dispute. The claimant has suffered an injury during the course of employment. Case of injury allied. It has a provision.
Not bad.
In view of provisions of so provision of Employees Workmen Compensation Act, the claimants are entitled to 12% interest 1 month from date of the accident. The tribunal has granted 6% interest from 23/4/2011. ಯಾವ accident ಆಗಿತ್ತು?
Accident ಆಗಿತ್ತು 23/3/2011.
ಅದು ಡೇಟ್ ಕರೆಕ್ಟ್ ಹಾಕಿದ್ದಾರೆ.
Correct ಆಗಿತ್ತು.
Yes. View of source of provision. The judgment and award passed by the tribunal as modified. That the claimant is entitled for the compensation of rupees 8,46,280 along with 12% interest from 23/4/2011 till it is realized. Yeah.
If they don't enter the best period.
With the delay of 293 days, he is not entitled for the interest for delayed period.
Number 20 months, Girish Ji, Maladagar, Appellate.
Yes, madam. weeks time is granted to do the needful. The copies have deposited that government copies for having deposited the remaining amount able to the additional deposit right for. Yes, Mr. Anand.
Number 32 is Sitaramala.
Yes. The top subjects.
Number 53, Suresh Lakhar.
For the appellant, my lord. In this case, 1 week time may kindly be granted, my lord. I have to produce some decisions
Yes.
regard to this maintainability of the petition.
Where the challenging the MVC is not maintainable. Yes. Use this method after 2 weeks of request of counsel for the applicant.
Number 54, Ramesh Reddy.
For instead of liability and DL, please not. Please turn the after Okala, please. I have deposited the amount 9/5/2019 to 10/10/2023 ಅಂತ 12% ಡೆಪಾಸಿಟ್ ಮಾಡಿಬಿಟ್ಟಿದೆ. ಇಲ್ಲಿ 3,377 ರೂಪಾಯಿನ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ಬಿಕಾಸ್ ಅವರು ಇಲ್ಲಿ ತನಕ ಮೊನ್ನೆ ಫೈಲ್ ಮಾಡೋ ತನಕ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿರ್ತಾರೆ. ಆಸ್ ಅಂದ್ರೆ ನಾವು ಚೆಕ್ ಡೆಪಾಸಿಟ್ ಮಾಡೋ ತನಕ ನಾವು ಎಂಟರ್ ಅಮೌಂಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ.
Now that you have to deposit 3,377.
ಅಲ್ಲಿ ಆಸ್ ಪರ್ ಆಫೀಸ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅವರು ನಾವೇನ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ತನಕ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿರ್ತಾರೆ. ನಾವು ಚೆಕ್ ಇಂದ ಡೆಪಾಸಿಟ್ ರೆಡಿ ಮಾಡಿ ಅಲ್ಲಿ ತನಕ ನಾವು ಮಾಡಿರ್ತೀವಿ. ಡೆಪಾಸಿಟ್ ಇಂಟ್ರೆಸ್ಟ್ 6 lakhs ಅಮೌಂಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಮೌಂಟ್ ಅದು ಕಟ್ಟಿದ್ದೀವಿ.
Yes.
Kindly pay the bill.
Issue notice. Yeah.
EC.
And award dated 15th July 2023 passed by second additional senior civil judge JMFC Shimoga in ECA number 3 of 2020.
Kindly have to next Wednesday, please. Kindly condone the delay and postpone next.
Yes, there is a delay of 45 days. For the reasons stated in that accompanying affidavit, delays condoned. IA 1 of 2021 is allowed.
Please, next Wednesday, I'm ready for this.
Next week.
Appearing for the respondent number R2.
Records beta.
Please, madam, liability fixed is owner balance.
There is a delay of 527 days in filing an appeal. Yes. Yes, madam. You have any objection for condonation of delay?
No objection, but the interest during that period, interest can be waived.
Yes. For the reasons stated in that accompanying affidavit, delay of 527 days in filing an appeal is condoned, subject to condition that appellant is not entitled for the interest in case if we succeed in this appeal. Claimant's appeal tane.
Please, madam, claimant's appeal.
Liability is fixed on the owner.
Please, madam, owner.
Owner is served.
Yes, my lord, third it is.
R2 ಯಾರು? और अशोक नायक ಯಾರಿಗೆ appear ಆಗುತ್ತೆ?
R2.
Huh?
R2.
I am for respondent, madam. Cholamandalam.
Cholamandalam. ಯಾಕೆ ಎರಡು ಇನ್ಸಿಡೆಂಟ್ಸ್? Yes, owner is the Hanmantappa is not appearing. Yes. Office is not admit. Yes.
People kindly call for the TCR claim. Problem is there.
Yes. As we condone delay, office is directed to secure original records.
Please.
Number 27, Srinivasamurthy Esquire.
Yes, Srinivas Murthy. Notice.
Number 28, Edu Prakash.
Claimant Claimant appeal. Owner's appeal. Yes, notice.
Deposit ಮಾಡಿದ ಅಮೌಂಟ್
ಎಷ್ಟು? ಪೂರ್ತಿ ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರಲ್ಲ ECA. Why owner has been made liable, Mr. Insurance policy review one.
Lali, compensation I can do.
I think there is no policy on what ground you are challenging. What ground you are challenging, Mr. The quantum you are challenging, yes, third issue notice. Yeah. Judgment and award dated 3rd July 2019, passed by Senior Civil Judge, Commissioner of Employees Compensation at Shimoga, number 37 of 2014, till next date of the year.
Number 28, 48.
I number 2, my lords, we have filed an application for the amendment of claim petition, my lords.
Year 2 for amendment of claim amount.
It's 5 lakhs rupees, my lords.
Claimant's appeal.
Please, my lords.
Notice.
Lords, notice has already been awarded. My lords, we have already taken the process in respect of one also, my lords. Respondent number 2 has been dispensed, my lords.
Where is that notice? Order idea notice. The respondent and main appeal as well as value. Exactly. Can I get the notice?
We have taken, my lords.
Process, what is it?
On 26/6 of 23, my lords, we have taken, my lords.
Yes.
And we also filed a dispensation in respect of part 2, my lords.
Learned Council for this court has issued a notice on 23/6. Learned Council for the appellant submits that he has paid the process on
26/6, my lords.
26/6
Of 2023.
23. Office to verify and proceed further. Yeah, the dispensation can be recorded.
On respect of part 2, my lords.
Memo element.
Along with that one, we have filed. With process.
Yes. Notice to R.
R2 is there. We have filed dispensation.
R2.
R2.
Yes. Learned Council. Appellant submits that notice to R2 may be dispensed.
Please, my lords.
To that effect, he has filed a memo in that office. Notice to respondent number 2 is dispensed at the risk of the appellant.
Respondent case for appellant. My lord, this case, my lord.
Yes, Manjunath. Now that what is it? It's like
My lord, I filed an application to bring the LRs on the record, my lord. Respondent has died, my lord. Before the appellant filed the appeal, my lord, the respondent had died, my lord. My lord, the appellant has filed the appeal on 10/1/2023, my lord. The respondent died on 30/6/2022, my lord. After the respondent died, my lord, without bringing the
Chandra Naik is dead. Yes. Now they have filed an application. We'll allow that.
Yes, my lord.
Yes.
Either we may be given permission to file appeal, application, or their application will be allowed.
Yes, but you have no objection. They are the LRs.
Yes.
That relationship, Mr. Manjunath.
The wife and the sons of the deceased, my lord. I filed an genealogical tree also, my lord.
Yes. Respondent number 1 is died. The LRs of deceased respondent number 1 has filed IA number 3 for confirmation of delay in filing LR application. There is a delay of 374 days in filing an LR application. Both the parties has the appellant has no objection. Continuation of delay and allowing that LR application to bring LRs of deceased R1. Hence, delay of 374 days in filing an LR application is condoned. IA 3 of 2023 is allowed. Consequently, 4 of 2023 is allowed. Abatement is set aside. IA 5 of 2023 is allowed. LRs of deceased respondent number 1 is permitted to come on record. Learned Council for the appellant is permitted to amend the cost item. Yes, amend it.
We have served notice on government advocate, that may kindly be taken. We have served copy.
Have you served the copy?
Yes, Your Honor.
Yes. Government advocate, government pleader is directed to take notice for respondent number 2. AGFR R2 ಇದೆಯಲ್ಲ? ಆಯ್ತು.
Serve.
ಅವ್ರು ಮೆಮೊ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ. There is already their name has been shown. Yes, you amend it.
My lord, I filed an application IA number 6 to withdraw the deposited amount. As per the state interim order, my lord, the appellant has deposited the 50% of the award amount, my lord. So, my lord, the competent authority, my lord, so they acquired the land of the respondents, my lord, measuring 1 acre 11 guntas, my lord. The competent authority SLO has awarded of rupees 77,000 rupees per acre, my lord.
Let him amend and bring that LRs on record. Then we will hear that application.
Will amend.
Yes.
Date may be fixed, my lord.
Yes, next week.
It may be, my lord. The bill matter is posted on 17th, my lord.
Yes. Hmm. 43 days in filing. Ready, madam? Ready, Mr. We have 43 days in filing and appeal is controlled. IA 1 of 2023 is allowed. Yes.
The case of injury, Your Lordship.
Hmm.
Here, pain and suffering enhancement has been done and loss of future abilities.
What is that disability, madam?
Your Lordship, doctor is examined and given 16% to whole body, but the tribunal is taken scaled down to 10%, Your Lordship.
Where is that discussion? In that petitioner has got permanent disability, left lower limb is 49%, whole body is 16. Tribunal ಎಷ್ಟಾಗಿದ್ದಾರೆ?
10%.
What are that injury, madam?
Your Lordship, injury is fracture of pelvis and crush of injury left leg, Your Lordship. And thrice she's been operated for the same.
Yes, what is that income?
Income is taken as per the 14,500.
Correct idea,
2020 accident.
correct idea. That disability.
Please, Your Lordship.
How many days you are in that hospital, madam?
She was an inpatient in BGS hospital from 11/8/2020 to 26/8/2020, Your Lordship,
Yes.
and underwent fasciotomy with the betterment on 15/8/2020.
How many days? Yes, Mr. Malikarjun, huh?
29 days.
29 days. Yes, that's all.
Please, Your Lordship.
So and so learned counsel appearing for Bennett has contended that to the extent Bennett has suffered grievous injury. Doctor has been examined as PW2. Evidence he has deposed that the claimant has suffered permanent disability of left lower limb. The extent of 49%. And whole body disabilities is 16%. The tribunal has assessed whole body disability is 10% is on lower side. She further contended that to that extent, claimant has suffered grievous injury to an inpatient for a period of 29 days. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. She sought for enhancement of compensation. For contra, the Mallikarjun Reddy appearing for insurance company has contended that even though claimant has claimed that, even though doctor has deposed that claimant has suffered 49% disability to particular limb, 16% to whole body. Considering that evidence of doctor and considering that medical records and the health and avocation of the claimant, tribunal has rightly assessed whole body disabilities 10%. Further contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for or the learned counsel for the parties. Judgment and award. It's not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 11/8/2020 due to rash and negligent driving of driver of lorry bearing registration number AA51 AF 4035. Due to that accident, the claimant has suffered the following injury. Doctor has been examined as PW2. His evidence he has deposed that claimant has suffered permanent disability of left lower limb is 40% and whole body disabilities is 16%. Considering that the evidence of doctor and injury suffered by the claimant, that medical records, I have the opinion that whole body disabilities has to be assessed 60%. The tribunal has rightly assessed monthly income of the claimant as 14,500. 14,500, huh?
Please, Your Lordship.
And what is that multiplier? At the time of the
34 years, Your Lordship.
age of, he was aged about 34 years. The multiplier applicable to that age group is 16. Accordingly, loss of future earning has been reassessed as follows. To that extent, claimant has suffered the aforesaid injury, was inpatient for a period of 29 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that the evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of income during the later period for 3 months. Loss of immunity is from 17,000 to 40,000. Compensation awarded by the tribunal in the other hand are just and reasonable. That is allowed in part.
Your Lordship, request the DCR may be sent back to the tribunal.
Yes. Delay, yeah. Yes.
Obliged.
Yes.
The company appeal. My lord, the award amount is 42,000 rupees. Lord, I have deposited 50%.
No, why you are challenging on
On the ground of liability, my lord. On the ground of liability, the owner of the vehicle has produced the fake policy. Fake policy, and he has tampered it and he has produced. And we have also initiated criminal proceedings against him. Lord, that one, my lord, we have filed this. Lord, the award amount is 42,000.
Yes, heard. Yeah. Judgment and award dated
31/10.
31/10/2022. Caused in MEC number
In MEC number 528
of 2008.
2018.
Yes. Till next date of hearing.
Delay may be condoned.
Without here issuing notice to that other. Where is the other appeal?
Other appeal is not posted.
Only
Only one appeal.
in this case they have produced that fake.
Both the cases, both are connected cases. In that, so that appeal is not posted.
Yes. What is? Yes, Mr.
It's in case of the insurance company appeal.
The companies challenged the quantum as well as the negligence.
Negligence.
Yes, madam.
Where is that other appeal? Yes, madam.
Yes.
Sorry, my lords. It's an insurance company appeal on the ground that the claimant says that he's working as a government teacher and he continued in the same occupation. But he had awaited leave for only 4 days, whereas the tribunal has granted about 1,20,000 under loss of income during the later period. Only to that extent I have filed my appeal, my lords. Your lordship would find
Yes, or issue notice. Yeah. Payment and award dated 14 February 2023, passed in of MACT Srirangpatna in MAC number
it's a BC number 228/20, my lords.
228/20, subject to condition deposit entire compensation amount interest before this court.
Yes, ma'am.
Within 4 weeks.
Lord, claimant's appeal, case of death. Only
They got 2 weeks.
one point, my lord, it has to be considered. In all the heads, they have considered. This is what the government employees. UGC scale to consider as
Just income tandidare.
No, they have taken the income what they have produced before the trial court. UGC scale, my lord, 2016 onwards, she has entitled. Lord, I have produced the additional document.
I the income tagadmele Indian anta keltare. What is that your grievance?
The grievance is, my lord, the court has taken 75,000 odd. As per the UGC scale, my lord, 47 I have produced. Additional documents, my lord.
Additional document.
Yes, my lord.
Then he has to
Yes,
he has to verify. Now, why that tribunal has taken only 75? Then you have not produced that.
That document we have not got, my lord. That is the relevant point of time now.
I think to verify now.
Yes, sir.
Yes. Now you will condone the delay, Mr. Muralidhar.
Yes.
You will condone the delay. Delay of 68 days in filing. Appeal is condoned. IA 1 of 2023 is allowed. Yes. For vacating that interim order, yes.
It was a conditional order passed by this honorable court, my lords. They have to deposit 5
I
lakhs.
had no instruction, Your Honor. I had no instruction. I will be permitted to retire. Call next week. I will issue the notice. I will retire.
Where is that order for this thing?
610, Your Honor.
Interim order granted earlier extended subject to the complaint shall deposit the sum of rupees 5 lakhs. I shall deposit another sum of rupees 5 lakhs within 4 weeks. Now that you have filed an execution.
Yes, my lords.
Yes, you prosecute that will say that interim order is not complied. It will not come in the way you to prosecute that execution.
Yes, my lords.
Yes. This court has granted an interim order on 6/10/2023. Subject to addition. The appellant has not complied that condition. Hence, interim order granted by this court is vacated.
And further,
it is the respondent plaintiff.
I am for the reason.
Respondent plaintiff, sir.
Respondent plaintiff
Yes,
is permitted to execute that decree. Before the,
And lower court may be directed to allow 2 applications has been filed, my lords.
that is different. You don't ask relief in this case.
Yes, my
if they have not done anything, then you have to challenge it.
Yes, my lords. Already police protection ಕೇಳಿ ನಾನು application file ಮಾಡಿದ್ದೀನಿ.
ಮಾಡ್ಕೊಳ್ಳಿ.
ಮಾಡಿದ್ದೀನಿ already. The application is pending, and this honorable court may direct the lower court to allow that application and
Why? That
because
is not,
my lords,
they are not allowed. You have to challenge, Mr. It is his appeal.
the intention is very clear, my lords. They want to drag the matter, and the same submission will be made before the lower court also. So for that reason, my lords.
No, now I said pendency of this appeal will not come in the way of the plaintiff to prosecute the execute this decree. Then you execute it.
Yes, lords.
Yes. Other matter.
May be
Vacated pending of this appeal. Not come in the way of the plaintiff respondent to prosecute execute the decree.
inspection, I may be permitted to return.
You do that in procedures, you have to service notice and then, yes. I could have dismissed it for default, but anyhow, you have not issued notice, therefore, you should not be affect your rights, therefore I said, interim order is vacated, let him, this thing, yes. No, again, 3 of 2023 is filed for vacating interim order. Since interim order is granted subject to so much condition, I never extract. Interim order is vacated. Let's see if this appeal will not come in the way of.
Vijay Kumar.
Yes, Vijay Kumar.
Appellant Millard KSRC appeal. Accident between the two vehicles car. He is occupants in the car. The car accident is total negligence of the driver of the car. We have produced the photographs. Our bus is on the extreme left side of the road. The car came and dashed against our vehicle. I am ready to deposit 50% of the award amount before the High Court, my lord.
No, there is a delay, Mr. Vijay Kumar.
Yes, I am ready to deposit 50% of the amount. Issue notice.
If there is a delay, you have to deposit the entire amount if you want to stay. If you don't want any stay, I will issue notice. In delay matters, usually I ask to deposit entire because
I'll deposit before High Court, my lord.
Yes, yes.
High Court.
Stay of judgment and degree dated.
And the respondent number.
Pass by. Yes,
my lord, respondent number 2, my lord. Yes. He is the driver of the car. My lord. My lord, he is the driver of the car, my lord. Notice may be dispensed with, my lord.
You don't want
number 2. Respondent number 2 before the tribunal. Before High Court. Please, my lord.
Subject to deposit of entire compensation amount before this court.
Please, my
lord. Notice to R1 is dispensed at the risk of the appellant. Issue emergent notice to respondent number 2. Yes. No, 2 is that driver, Allah. As notice to R2 is dispensed. Issue emergent notice to respondent number 1.
Previous matter, serial number 36 matters. In that earlier WP, they have deposited some amount, my lords. Permit me to withdraw that amount.
Where is that?
In lower court.
Application permission. In this case, they are not.
In this case, not.
Then how can you entitle for this? Yes.
Great.
Yes, Shashidhar.
Connected map is on it.
Yes, madam. What is this?
There are 3 appeals that are filed by the insurance company on the ground of negligence.
Not connected.
Yes, my lords.
How they are connected?
3 appeals by me, 32, 25, 26 and 27, my lords. And there are other 2 appeals, 11, 62 and 64 by the claimant.
Serial number 38. 38 bar 1. 38 bar 2. How they are connected really? First. You don't have.
I don't.
You tell that number, madam.
32, 25.
32, 25.
32, 26.
Yes.
32, 27. These are the appeals filed by me, my lord, sir. 1162 and 1164 are the appeals filed by the claimant.
1162
and 1164, my lords.
1164 and 1165 is also.
1165 is not connected.
Why?
It is. I'm not.
No, that in National Insurance Company Limited, Davangere is heard. It is Davangere.
Yes, but it is not connected with these appeal, my lords.
No, I think you have filed 3 appeals.
Yes, my lords.
I think he is also filed in a 3 appeals.
He has to say that whether all these 3 appeals.
Or Shashidhar matter so connected it up. Gurudev Prasad matter is different.
Yes,
Mr.
Yes, it's there also. 2 more appeals.
Yara?
It's there.
R Shashidhar 3 matters ಇಲ್ಲಿ ಬಂದಿದಾವೆ.
Okay. ಆಮೇಲೆ ಕೇರ್ಫುಲ್ ಆಗಿ ಹೋಗು.
Raj ಅವ್ರದ್ದು 3 matter ಬಂದಿದಾವೆ. I think this 3 has connected to this. Yes, only that Gurudev Prasad matter has to be dealing.
Yes, ma'am.
Yes. MFA 767 of 2020 directed to be dealing with MFA 3225 of 2019. Alala. 1162 of 2020 and connected matters. Directed to be posted this matter next week. Ready, Dira? Yes. Nimdo?
There.
Yes, Mr. Shashidhar. You have filed 3 appeals.
4 appeals.
Huh?
4 appeals. Claimant. Total 4 motor vehicle cases.
ಇಲ್ಲಿ 3 ಇದೆವಲ್ಲ
ಇನ್ನೊಂದಿದೆ ನಂಬರ್ ಕೊಡ್ತಾರೆ.
ಕೊಡಿ.
3224/19 is filed by the
ಇದರಲ್ಲಿ 38.6 ಅಲ್ಲಿ Geeta Raj is direct. Respondent number 2 is served unrepresented. Geeta Raj is directed to take notice. You take notice. You have filed only 3.
I have also filed, there is another appeal,
ಅವು ಎರಡು ಕೊಡಿ ಎಲ್ಲ ಕ್ಲಬ್ ಮಾಡ್ಬಿಟ್ಟು
3224/90. It is my appeal.
1170/19 is the filed by the claimant.
Is 3 plus 3 6 appeal has to be called along with that other 2 appeals.
Records may be called for.
Yes, office is directed to secure original records. Yes, now that Gurudev Prasad and ready. Yes. 767 of 2020. No, 38.4. Whereas it is not connected. Serial. Wait, Mr. 38 has to.
Silence.
I am for respond number 1 minute.
Yes. Number?
Dislocation of left antrum and right.
Para number 13 now.
14. Issue number 2.
Yes. Compound type 3B fracture dislocation of the left ankle. What is the evidence of the doctor? There is that discussion.
Para number 17 minutes.
17. 46%. 15%. What is that tribunal considered? Tribunal considered. What is that income?
Instead of 11,000, they have taken 8,000.
Yes, claim ಮಾಡಿದ್ರಿ. What is the date of the accident? 17 under 11,000. Yes. 40 days. What is that 5 days?
5 days inpatient.
Patient suffering, medical expenses.
Only income aspects.
Amenities has given less. Yes. Interest has put it
9% and then 6%.
6% for enhancement. The Gurudev Prasad Learned Council appearing for claimant has contended that at the time of the accident, he was earning 30,000 per month. Tribunal has assessed personal income of the claimant as 8,000 per month is on lower side. Further contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 5 days. He has suffered lot of pain during the treatment. He has suffered with disability and unhappiness throughout his life. The compensation awarded by the tribunal. Loss of income during the later period ಕೊಟ್ಟಿದ್ದಾರಾ? Yes. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. The tribunal has not granted any compensation for loss of income during the later period. Hence, he sought for enhancement of compensation. Contra, the Reddy Learned Council appearing for insurance company has contended that even though claimant was claimed that he was earning 30,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed nominal income of the claimant as 8,000 per month. He further contended that Injuries suffered by the claimants are minor in nature. He was inpatient only for a period of 5 days. Considering that evidence of doctor and injuries suffered by the claimant, compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is just and reasonable. The interest awarded by the tribunal, 9% is on higher side. It is sought for section of appeal or the unmet counsel for the parties. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 15/4/2017 due to rash and negligent driving of driver of car bearing registration number KA01 AG 6594. Even though claimant has claimed that he was earning 30,000 per month as a businessman, he has not produced any document to establish the same. The circumstances, personal income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income has to be considered as 11,000. Tribunal has rightly assessed whole body disabilities 15%. Multiplier applicable to that age group 40 is to multiplier 15. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has suffered the disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities 50,000 to 45,000. Claimant is also entitled for loss of income during the later period for 3 months. Hence, the compensation awarded by the tribunal, other hand, are just and reasonable. Enhanced compensation amount carries 6% in. Delay. Yes, delay of 159 days is condoned, not entitled for the interest for enhanced compensation amount.
Last title does not tally. The claim value differs from judgment and award.
Yes, why that judgment and award claim is differ? Yes. Unmet counsel for the appellant is accepted. Office objection is overruled.
Number 39 appearance in number 40, 35 for appellant.
In this case, appear for appellant. All 3 cases. One is death case, another injured case, your lordship.
Will I appear for the respondent, my lord?
Yes, Segre. Ready?
Yes, my lord. Ready, my lord.
Yes, ready.
In first case, your lordship, 1813. The petitioners are the legal heirs and representatives of the deceased Ansuya Pai. She died in the accident. Only 15,000 award, your lordship.
Right.
The legal heirs ಅಂತ ಹೇಳಿಬಿಟ್ಟು ಅವರಿಗೆ only 50,000 ಕನ್ವೆನ್ಷನಲ್ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾರು deceased is?
This is legal heirs of the deceased Ansuya Pai.
Who is dead? Ansuya Pai is dead.
Dead. Aged about 61 years at the time of accident.
61 years.
65 years.
Sons and daughters. Sons and the daughters of the deceased Ansuya Pai.
Son.
House.
ಯಾವುದು MEC?
MEC 386.
386. Ganesh. Kumar.
All are petitioners, daughters and sons.
Daughters and sons. Daughters are married, huh?
Married.
Paragraph 17, my lord. Paragraph 17.
7.
The income taken by the tribunal only 5,000, your lords. 2015 accident.
17. Petitioners are respectively 40, 36, 48, 38 years. Among them, petitioner number 3 to 5 are.
Para number 25 last.
Immediately residing in the south. 6 of the petitioners stated deceased was earning 5,000 per month Karnataka. She was also working as an helper at Chimonga. At the age of his.
Plan number 18 last 50,000.
You have claimed that she was earning 5,000 per month.
5,000, but in addition working over.
ಎಲ್ಲಿದೆ ಆ ತರ
That is
ನೀವ್ ಹೇಳಿದ್ದೆ 5,000 ಅವ್ರು 5,000 ತಗೊಂಡಿದ್ದಾರೆ.
only for salary certificate by the
65 years
charitable.
What is that multiplier?
Multiplier is 7 ಬರ್ತದೆ. 61 years.
Then 50% has to be deducted.
ಹೌದು.
ಅಲ್ಲಿಗೆ ಎಷ್ಟಾಯ್ತು?
As per the legal service authorities 9,000 euros.
ಅಲ್ರಿ ನೀವೇ 5,000 ಅಂದಾಗ 9,000 ಬರಲ್ಲ.
In addition business ಮಾಡ್ತಾ ಇದ್ರು ಟೈಲರಿಂಗ್ ಎಲ್ಲ.
Show me that evidence.
The society stated working as a daily wages labor 5,000 per month. Decided the matter.
ನಿಮ್ದೇ ಎವಿಡೆನ್ಸ್ ಇದ್ರೆ ನಾವ್ ಹೆಂಗೆ ನನಗೆ ಬರೋದೇ 5,000 ಅಂತ ಅಂದಾಗ ಇಲ್ಲ ನಿಮಗೆ 10,000 ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. If you are claim that 5,000. Yes. 5,000. Future prospects ಇಲ್ಲ 50.
Future prospectus is not there, man.
2,500 multipliers.
65 years. Multiplier ಎಷ್ಟು?
9 ಬರ್ತದೆ.
65 years.
65 years.
65 ಗೆ 7.
7. 2,10,000.
Yes, 2,10,000.
And other loss of convention led to 5 members.
5 members, daughters and
Daughters and sons.
5,20,000.
My humble submission is, my lord, for that lot of consortium, your lords may kindly appreciate, my lord, they are the major sons and married daughters.
Consortium love and affection ಗೆ major minor ಎಲ್ಲಿ ಬರ್ತದೆ?
ಅಲ್ಲ ಅದೊಂದೇ ಅಲ್ಲ, my lord, my humble submission is, my lord, your lords may kindly recent latest judgment of Supreme Court.
ಕೊಡ್ರಿ, ಒಬ್ರು ಕೊಡ್ತಾ ಇಲ್ಲ, ಎಲ್ಲರೂ ಲೇಟೆಸ್ಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಲೇಟೆಸ್ಟ್ ಅಂತ ಇದ್ದೀರಾ. We are ready to accept latest, mister. You give that latest judgment. Nobody is ready.
Bhagat Singh Rawat, my lord, Sri Ram Janam.
Kodri, where is that? You give me and explain and convince me, then I will consider. I am bound by that. Nobody is giving that judgment.
My case.
Let them give. If Supreme Court judgment is there, I have to consider. Where is that judgment?
My lord, even my lord, this honorable court division bench, my lord, considering that.
See, I'm whether I have this thing right to see that judgment or not.
That is there, my lord. 230, my lord. 230 may.
230, yes. 230. You produce that. 230. Yes.
And other two matters can be disposed of, my lord.
ಎಲ್ಲ ಒಟ್ಟೆ ಮಾಡೋಣ, ಕಾಮನ್ ಫ್ಯಾಕ್ಟ್ಸ್.
Yes.
Yes. Yes, Mr. Ready. Where is the Srinivas?
Yes, income.
Pass on. Or next week. ಏನಾಗಿದೆ? On what ground you are challenging?
Single ground, no DL at all, no liability ಅಂತ.
No DL and no liability. No, who is appearing for the owner?
Served and other presented.
What is that finding of the tribunal?
That the police have not charge sheeted him on the DL issue anta.
Ala sari, now that liability on you.
Liabilities on
now
me.
that we have to say pay and recovery.
No liability at all. I'm supported by a division.
If no DL is there, no pay and recovery.
No DL at all.
No DL at all.
Last may kindly take to paragraph number 28, Malaz, in page number 18.
Yes.
May I read, Malaz?
Yes.
The Allied Council for the Insurance Company further placed reliance on the judgment of the Apex Court reported in AI number so also. The Honorable Apex Court in Swanson's case referred above has clearly held that the mere absence of fake or invalid driving license at relevant time not in themselves available defenses for insurance company under 149(2)(a)(2) of the MB Act. It is further observed that the rider of the vehicle admittedly did not possess any driving license and the owner consciously let him ride the vehicle, and in such circumstances, the insurer is entitled to succeed in its defense and avoid liability. In paragraph 105 of the said judgment, the larger bench of the Honorable Supreme Court laid down the guidelines as to under what circumstances the insurance company can raise defenses under section 149(2)(a) subclause 2 of the MB Act, and instances were quoted. In view of these guidelines, it is evident that not possessing driving license is a valid ground for the insurance company to succeed in the incident case, and the rider was not possessing valid and effective driving license. These observations were again reiterated by the apex court in Pappu's case, referred supra, and they were reproduced in paragraph 18. Considering the said aspects, it is evident that respondent number 1 owner who consciously handed over his vehicle to a person who did not possess driving license cannot take benefit of his own wrong, and insurance company entitled to raise the defense under section 149.
There is no question of pay and recovery, division bench, sir. No DL.
In this case, my lord, the charge sheet, my lord, the no offense was made out, my lord, the finding of the tribunal kindly see, my lord, the para 19, my lord.
On what ground you are saying that there is no DL?
In
Is
fact,
it proved that there is no DL?
in fact, Manoj, may kindly take to ink page number 19, Manoj. Page number 19, bottom 5 lines, Manoj. Basing on this citation, learned counsel for the second respondent argues, and even in this case, the owner who is the first respondent has stepped into the witness box, has not stepped into the witness box, nor he has given any answer to the notice issued by them under order 12 rule 8. In view of the contention, the second respondent, I have gone through the entire judgment.
That citation offense alleged against the driver. No, they have given a notice to him. Owner has not that presumption is that there is no DL.
Even then, my lord.
They have made their effort to do it, but he has not come forward and said that what else they can do it.
But even they have not examined the RTO also, my lord, and even charge sheet also, 181 not reflected in the charge sheet. So in the absence of that, my lord, the insurance company is burden upon the insurance company. They have not examined the RTO. Merely only issuance of notice, my lord, not sufficient to, my lord, quote that the owner is there.
In which law it says?
I will produce.
You produce that, we'll see. How you have to be established that there is no driving license. Yes, we'll admit it, because even then, if this appeal is allowed, ultimately owner is heard 100%. Then matter has to be heard. Yes, because in his absence we cannot decide in that orders list. It has to be in the hearing. Heard. Admitted. This will give. Heard. Admitted.
My lord, in this case, I pay for the appellants, my lord.
Yes.
It's a case, contributory negligence, my lord. Kindly, TCR may be.
Yes, Ravi is Sampati.
He's out of station. Kindly.
Next week.
Yes, my lord.
Records is necessary.
Yes, my lord. It's a case of contributory negligence, my lord.
Yes, heard, admit.
Much obliged.
Yes.
Case of death. Yes. Date of birth still 31/10/2019.
19. Yes.
But income alert taken alert 9,500 instead of 14,000.
Claim ಮಾಡಿದ್ರಿ.
Claimed my lord is 30,000 as income. 30,000 has been
Peter prospect ಕೊಟ್ಟಿದ್ದಾರಾ?
40% add
ಕೊಟ್ಟಿದ್ದಾರಾ?
ಮಾಡಿದ್ದಾರೆ.
Deduction?
Deduction my lord third.
ಮಾಡಿದ್ದಾರಾ? Where is that discussion regarding that?
Number 3 my lord.
Yes, 27 years, huh?
27 years. 17 multiplied.
17. The rental may not only 70,000 has been granted. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? Claim by Pooja. ಯಾರ್ಯಾರು? Not the wife, daughter, and mother of the deceased. Yes. Yes, Mr. That's all.
This one. And there is no proof of the income what they
Yeah, that will take that notional interest.
very contributory negligence.
Contributory negligence.
Yeah, 10% of contributory negligence. That was also
Deducted. Did the tractor trailer from behind Danta? That will retain. Yes, that is a challenge. Challenge. Yes. What so learned council appearing for? Issue number 1 discussion. Issue number 3. Liability ನಿಮ್ಮಲ್ಲೇ negligence 10%
with regard to that.
Issue number 1.
With regard to that, page number 14 of the judgment.
14 of the judgment.
Because the complainant has mentioned in the complaint itself that her husband thought that the tractor was
Complainant
moving.
mentioned in her complaint that her husband thought the tractor was moving and later on become to know that tractor was parked on the road. He failed and tried to stop the vehicle but failed to control his motorcycle and failed to keep distance. ಅವ್ರೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ದಾರೆ. Yes, not so learned council appearing for claimant has contended that the driver of the tractor alone is negligent in causing that accident. The tribunal has error in held that it was contributed 10% to the accident. Other contended that the complaint is not against the driver of the tractor. The police has filed an FIR and charge sheet against the driver of the tractor. The Mahazur sketch IME report clearly disclosed that the driver of the tractor alone is negligent in causing the accident. The finding of the tribunal that deceased has contributed 10% to the accident is contrary to the material available on record. In respect of quantum, he has contended that the time of the accident, deceased was aged about 24 years, doing a welding work and earning 30,000 per month. The tribunal has awarded considered monthly income of the claimant as deceased was 9,500 is on lower side. Party has contended that view of judgment of apex court in case of magma, claimants are entitled 40,000 each. It is sought for enhancement of compensation.
They make a submission. There is a contention taken by the respondent number 2 that the respondent number 1 does not have a valid driving license.
Who?
The tractor driver.
What is the finding of the tribunal?
There is no issue also.
You have not challenged. You have not challenged and satisfied. Satisfied the trial court award. Yes. Per contra, so and so learned counsel appearing for insurance company has contended that it is very clear from the evidence of the parties and material available on record. Deceased was dashed against that parked tractor from the behind. He was riding that motorcycle in rash and negligent manner. Considering that evidence of the parties and also considering that complaint, the tribunal has rightly held that deceased has contributed 10% to the accident. Further contended that even though claimant has claimed that deceased was earning 30,000 per month, they have not produced any document to establish the same. Therefore, tribunal has rightly assessed personal income of the deceased as 9,500. Also, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal just and reasonable. The interest awarded by the tribunal 9% is on their side. Hence, he sought for this for the appeal. Heard the learned counsel for the parties. Use judgment and award. The case of the claimant that on 31/10/2019 at about 7:45 PM, deceased Irfan was riding the TVS Victor bearing registration number KA02EH6495 from TB Cross towards his house on extreme left side, DVJ Road. When he proceed, DVJ Road, Chikpalapura. At the time, the driver of the tractor bearing registration number KA04KA40G282, trolley bearing registration number KA40G283 was moving ahead of the TVS scooter, suddenly stopped in the middle of the road. Hence, deceased was dashed behind the tractor and fell down and sustained injury. Injury. In the complaint, exhibit
P1.
P1. It is clearly mentioned that
P2, P1 in the FIR.
Exhibit P1 complaint and exhibit P2 FIR, it is clearly mentioned that the tractor was moving. No, that it is clearly mentioned that tractor was parked on the road. The deceased was dashed behind the tractor. By considering that FIR, complaint and IME report, the tribunal has rightly held that deceased has contributed 10% to the tax extent. There is no error in finding of the tribunal in respect of issue number 1. In respect of quantum, even though claimant has claimed that deceased was earning 30,000 per month doing a welding work, but they have not produced any document to prove the same. Under the circumstances, no national income has to assess as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2017-19, the national income has to be considered as 14,000. The tribunal has rightly added 40% of the income of the deceased for future prospects and rightly deducted 1/3 of the income of the deceased for personal expenses. Multiplier applicable to the age group 25 is 17. Accordingly, loss of dependency has been reassessed as follows. In addition, 15,000 for loss of estate, 50,000 for criminal expenses. Limit number 1 is entitled 40,000 in lieu of judgment of apex court in case of magma. Limit number 1 is entitled 40,000 for spousal consortium. Limit number 2 is entitled 40,000 for parental consortium. Claimant number 3 is entitled 40,000 for filial consortium. Finance compensation amount carries 6% interest. Insurance company is directed to deposit 90% of the award amount with interest. Yes.
Case of violation of DL, my lord. Can't recover.
Who is appearing for the owner? Now that what is the finding of the tribunal?
Liability fixed against the owner, my lord.
Owner has not challenged.
Owner has not challenged.
Yes. Now that the tribunal has held the paint, no, only owner is liable.
Yes,
He has not challenged.
They have
Now
not
that
challenged.
we are seeking for a pay and recovery, some extent you can breathe.
Passenger carried in goods vehicle.
But the passenger carrying goods vehicle also pay and recovery is policy is there.
Policy, date of birth and policy has been enforced.
What else remaining?
Enhancement correct. Award amount is properly awarded.
Only liability. Yes. So and so, learned counsel appearing for the claimant has contended that at the time of the accident, the offending vehicle was covered with valid insurance policy. Driver of the offending vehicle was not having valid effective driving license. The tribunal has fastened the liability on the owner of the offending vehicle. In respect of claimant is concerned, in view of judgment of apex court in case of FOFU and full bench of this court, first instances insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. To that effect, he sought for modification of judgment and award passed by the tribunal. So and so, learned counsel appearing for insurance company has contended that admittedly, driver of the offending vehicle was not having effective driving license. He has violated the policy condition. Therefore, the tribunal has rightly exonerated the insurance company from payment of compensation. Hence, he sought for dismissal of the appeal. Then contention. The counsel for owner of the offending vehicle has contended that the offending vehicle was covered with valid insurance policy. Therefore, insurance company has to pay the compensation. Third, the learned counsel for the parties peruse judgment and award. It is not in dispute. Alegowda died in road traffic accident occurred on 17/5/2014 due to rash and negligent driving of driver of auto rickshaw bearing registration number AA543384. The tribunal, in respect of liabilities, is concerned. The only contention raised by the appellant regarding that liability, the tribunal has exonerated the insurance company and fixed the liability on owner of the offending vehicle on the ground that the insured has violated the policy condition. The goods vehicle he was having any driving license to drive.
No, my lord. They didn't have a driving license. DL ಇಲ್ಲ.
DL ಇಲ್ವಾ
DL ಇಲ್ಲ.
DL ಇಲ್ಲ, DL ಆಮೇಲೆ ಎಕ್ಸ್ಪೈರ್ ಆದ್ಮೇಲೆ ಆಕ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ಮಾಡ್ತಾರೆ.
DL earlier it was there in the interven it was not there. Yes. He has violated the policy condition. The tribunal has exonerated the insurance company. Since the offending vehicle was covered with valid insurance policy, in view of judgment of apex court in case of FOFU and full bench of this court, in respect of claimant is concerned, the first instances insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. To that effect, to that extent, the judgment and award passed by the tribunal has modified as follows. The insurance company is directed to deposit entire compensation amount awarded by the tribunal with 6% interest within 6 weeks from date of receipt of the copy of this order with liberty to recover from owner of the offending vehicle.
Insufficient enhancement no ground for another. Claimants also seeking for enhancement.
You said only one ground, therefore I said.
Argument ಮಾಡಿಲ್ಲ ಅಂತ
ಅದರಲ್ಲಿ ಅವ್ರ ಎರಡನೇ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ the compensation awarded to the tribunal is on lower side, hence is sought for. I peruse that records and judgment and degree. The compensation awarded by the tribunal is just and reasonable. Third, issue notice of judgment and award dated 23rd December 2022. Sorry, ACT Kolar in MEC 299 of 2019. Subject to deposit 50% of the award amount with interest before tribunal or this court? Before the tribunal. Yes, Nagaraj.
Owner's appeal.
Owner's appeal.
Why? Payers recovery has been ordered.
What is wrong in that?
But
why that pay and recovery?
For para 22 para 22. Driving license early launch. Driving extract produced ಮಾಡಿದ್ದಾರೆ. Exhibit R1 and R2. The driving extract has been produced.
Not driving license.
Original ಹಾಕಲಿಲ್ಲ ಅಂತ ಹೇಳಿ.
You have any driving license?
Yes, you have produced it.
Here also you have produced.
Here I have not.
ಮತ್ತೆ ಇಲ್ಲ application ಹಾಕ್ಬಿಟ್ಟು produce ಮಾಡುತ್ತಲ್ಲ. Then they will insurance company are verify ಮಾಡ್ತಾರೆ. Then if it is there, they will accept it.
Exhibit R2 and R3 is there.
Correct ಆಯ್ತು. Original ಇಲ್ಲಿ produce ಮಾಡೋದಲ್ಲ.
Certificate copy.
ಆಯ್ತು ರೀ ಒಂದು application will issue notice. In the meantime, you issue notice. Yeah. Judgment and award dated 10th March 2023 passed by MESCT Udupi in MEC 737 of 2020. Yes.
Insurance company appeal. Challenge the future loss of income awarded by the tribunal.
Why?
On the ground that the claimant has continued in the services and he has resigned the job after 8 months of the accident.
Not because of this.
Not because of this.
What is the finding of the tribunal?
The tribunal has failed to discuss about the same in its judgment. Exhibit P4, 15 and 17 has been produced that statement.
Notice. Judgment and award dated 25th March 2023 by MESCT Bangalore MEC 4634 of 2021 subject to deposit of 50% of the award amount with interest for the tribunal within 4 weeks. Please. Next week. No, their appeal, there is no injunction order.
Yes, sir. So, last week put up by 2 more weeks, sir. That is on their own.
Next week, we'll see next week. 16th, 17th, 18th.
Yes, sir.
18th, yes. 18th. Yes, Mr. Anup.
Legal finding.
Also, we'll get that only 50% he has to deposit. Judgment and award dated 23rd June 2023 passed by ACT Bangalore in MEC 5850 of 2021 subject to deposit 50% of the award amount with interest before the tribunal within 4 weeks. Yes.
Matter. Trial court has granted injunction.
Yes. So let him argue his appeal. Yes.
His version.
Yes. Then we can.
Yes.
Yes.
They are connected, my lord. Arguments in one appeal would suffice for the.
Now, why connected two matters?
What happened is it's the same layout, and the respondents are common. And though the
No, you are in a defendant or a plaintiff?
I am the defendant. Defendants are common in the civil court. All the three cases, same defendant.
Three cases, yeah. Three cases, different suit or same suit?
Different.
Different suit.
Different suits filed by different plaintiffs.
Different suits, different plaintiff.
Defendants are common.
You are the
common.
Yes. No, you are the owner. You are claiming
yes,
that owner of the property. Yes. You are common that plaintiff are the purchaser.
Hello, now. Here, my case before the honorable trial court and before this court.
Yes, you just brief that. Yes.
Yes. For injunction was filed by. My lord, I am on 6978 first case.
6978. Yes.
My lord, a suit for injunction is filed by the respondent.
Yes.
Against the appellants herein.
Yes.
And
so for
injunction, fair injunction. That, my lord, an application for injunction was filed under Order 13 Rule 1 and 2. Ex parte order was passed, then we filed our written statement objections, and on merits, my lord, an order has passed allowing the application for injunction, which is now before challenge before this honorable court.
Yes.
On 13th of October 2023.
Yes.
My lord, the brief facts of the case of the plaintiffs, that is the respondents here, is that
yes,
they are the owners of the suit scheduled property, which is a site which bearing 2047, said to have been formed in the 2047 said to have been formed in judicial layout formed by the Karnataka State Judicial Department Society.
No, in that survey number formed in that which survey number?
That is what they say. It is formed in survey number 12/1.
12/1. Yes.
If my lord has heard us in detail, yes. Yes, what I don't have in brief again.
Yes.
Now his case is that the properties are formed in survey number 12/1 Allasandra village. Yes. They say that this particular property came to the ownership of the society in terms of a compromise which was entered into between the appellants, that is owners, and the society.
Yes.
In an original suit, OS 6381/1997.
OS
6381/1997.
6381.
Or 1997. They get this
compromise.
Yes.
Yes.
Now, Your Honor, my lord may kindly see the compromise decree, my lord, I have produced.
Yes.
Which is also, I don't think you'll deny it. Is at page 58 of the paper book.
Yes.
In page 58, my lord,
yes,
initially the suit was filed for injunction by us against only one Mr. Achyutan.
Yes.
Who is said to be disturbing with our possession of the entire 12/1 Allasandra 1 acre 26 quotas.
Yes.
Then subsequently, my lord, an application was filed to bring in this society.
Yes.
And then, my lord, compromise petition was entered into.
Yes.
My lord, if one way to look into the compromise, my lord,
yes,
it clearly states that this Munitayama and others, that is the appellants and their mother, etc., they had entered into an agreement of sale to sell this property to society. However, there were disputes, and it is in this compromise only we have agreed to sell the property to this particular society.
Yes. This survey number also.
Only the survey number we agreed to sell. In exchange, what happened? For the first time in the suit, some sites have been brought in. Some sites, my lord, were brought in, said to have been found in various other survey numbers, not in 12/1.
Yes.
Because it can't be in 12/1.
Yes.
Now, those sites have been given to the appellant. 2 sites to 1 appellant, 3 sites, etc.
Yeah,
and
in terms of that, this thing, instead of that land, they have
exchange. Correct. Exactly. So this is what has happened. Now, if one were to look into the sites,
yes,
that is at page 63. First thing is, there are sites 854, 853, 849, etc. Last site is 2093.
Yes.
Now, this particular suit schedule property of of 2047 is not found at all.
Yes.
My first submission is that. My second submission is, if it is his case, I don't know why he relied upon this compromise at all. If it is his case that now this particular land is now belonging to society here, and his site is formed in 12/1, well, then probably he might have some case. But kindly look into, I will not go further on the merits at all. Kindly look into the sale deeds produced by him. His sale deed is first sale deed by society itself is found in page number 82. That is not sold to him, his original allotee and then third sale, I think.
82.
82. 15th of November 2003. Now, in that, Karnataka State Judicial Society will sell it to M. Krishnappa. Now, preambulally, this talk about next page, vendors acquired and taken possession of various survey numbers. Allasandra village alli 12/1 is not shown at all. That alle nodi. Allasandra 9/1, 9/2, 11/1/2, 12/2A, 3. 12/1 is not shown at all. Then
ಇದು ಯಾರಿಗೆ ಯಾರು ಸೇಲ್ ಮಾಡಿದ್ದು?
ಈ society ಅವರು ಮಾಡಿರೋದು.
ಯಾರಿಗೆ ಕೊಟ್ಟಿರೋದು?
One Mr. Krishnappa.
Who is a party here?
No. Krishnappa sells it to another man and then you would put it. They're third buyer. Yes. Krishnappa is not. Then what happened? Krishnappa next document I produced. Krishnappa sells it to one Manjunatha. That is at page 98. And Manjunatha and the your council. They buy it in the year 2022, 25/11/2012, 100 page 150. P. Harish Kumar and his wife.
That Krishnappa sold to that Manjunath. There also is it mentioned regarding that this site?
This site that I have no objection. They have only sold same site 2047.
No, when Krishnappa has sold, the site number is there.
Same site number, 2047.
You said this is not mentioned there.
Not in the compromise. It's a sale deed. Sale deed. I am not disputing that sale deed.
No, society has sold
to Krishnappa.
You are saying that this property which is not in the compromise has been sold by the Krishnappa.
Yes. In that preambulally, what they say, we have formed the layout of various survey numbers which I have acquired. Other survey numbers but other 12/1 illa. So, which means the society at the earliest point of time accepts that this sale deed is not of 12/1.
But this site number is there.
Site number 2047 might be there, but it's not into 12/1 is my argument. It might be there. I cannot say anything on the site. It might be there.
Yes, but this boundary.
Boundary also might be there, correct. In fact, it is now. I'll show to the court how it comes into my favor. Now, what has happened is, I'll come again, my lord. The society has formed a layout in many survey numbers, including Allal Sandra village, and in their own sale deed, they say Allal Sandra dalli 11/1, 12/2A, 11/2, etc. But 12/1 they never mention. They themselves, the very first sale deed which they trace title does not mention 12/1. Then subsequent transactions happen. I also have no objection.
Yes.
Now, what happened, my lord, is that in fact, my lord is also probably aware and that many matters in the society were there. This society formed layout without any VDA approval at all. There's large scale illegality. And writ petitions were filed. Recently, on 22/9/2023, the learned judge of Honorable Court, my lord, has allowed the petition directing the VDA to approve the layout plan to be submitted. And all this along it was not there. So for the first time, it is said to be submitted. In that judgment, I will just take my lord to page 152. Yes. Other VDA memo is it. It says on 10/12/2015, a memo was filed by VDA which reads
where you are reading.
The judgment, a big judgment. Yes. 152.
Yes.
It says on 10/12/2015, a memo was filed by VDA. My lord gets which reads under society has submitted a layout plan in several survey numbers, Allal Sandra, Chikpam Sandra, Jakkur, etc. 156 acres, 10 to 23.5 quintas. So, my lord, as of this day, my lord, that is on 22/9/23 itself, 2 months ago, no approved layout at all of the BDA. They are just informed, they are saying. Then it says, society has submitted, authority is meeting.
This survey number 12/1 is there.
Is not there again. Resolved to approve layout plan in survey number 9/1, 2B, 3, 11/1, 2, 12/2A, 2B, 3, 4, 39, same like what they are told in that sale deed, match agate. So, even BDA also has not approved any layout plan for 12/1 because it was never acquired from them at all, except in terms of this compromise ratio. Even that compromise also cannot be acted upon. My lord, that might be an argument for merit. But the thing is, though it's a compromise decree of a court, which normally we say court decree need not be enacted. But here, in the compromise, they say, we enter into agreement, now I'm transferring it. Now, when they say transfer in terms of a decree, it has to be registered. It is like a that is what the judgment of Supreme Court says. An ordinary decree where you are saying partition, for example. For example, there are two brothers. So one brother says, yes, you need 50%. So because pre-existing rights are there, need not be registered, or some injunction, I will not interfere, or I say I am the owner and he says I will not. No, it need not be. But here, for the first time, a transfer of property happens from me to him, and those sites come to me. It requires registration. So, my lord, it is more than about 25, 28 years that deed is not registered. So, my lord, if they are going to back their case upon this particular document, it cannot be registered. No, my lord, it's like this. They have produced one layout plan. Let us for a moment accept it, my lord. I will accept it. Though, my lord, it's not approved, it's submitted. Now, kindly see where the site comes in as per them. It comes in survey number 9/1. My lord, I am making a clear-cut submission, my lord. If this particular site 2047 is in 9/1, I will not interfere.
No, see.
But if it is 12/1.
No. That is, see, they filed in a suit.
Saying that
I for an injunction in respect of particular suit scheduled property.
Yes.
If it is not related to you, why you are worried? Their injunction is there for that.
Yes.
See,
That is
suppose
because
person who is taking an injunction to that Vidhan Sabha, if you come to approach that High Court, that is you to protect your rights. You can't say,
okay, then I can make a submission. It's like this.
if it is not your
If it is says 2047 in 9/1, I am nowhere. I should not have made a party. Now he says 12/1.
No,
that is not right.
This is even mentioning that survey number, the boundary prevails over the survey number.
Yes.
Now that they have filed an only suit for injunction.
Yes.
It is not for an title.
Yes.
Declaration.
Yes.
We need not go into that. Yes. Only thing is that person who has come to that court for claiming an injunction.
The status quo can be maintained. It's open land.
I will come to that. They sought for an injunction in respect of the particular property.
Yes.
Now you are saying that this is not the property which belongs to you.
Yes.
Then why do you worry?
One submission. Can my lord see the plan? Why I worry? Why I am worrying is like this. If he is going, if my lord, if there is a clarity, if my lord were to say, I will not further say anything. If my lord were to say that site 02047, as per those boundaries showed, if it is not in 12/1, my lord, I have no objection to granting injunction.
Injunction is in respect of that boundary.
Now what he's doing
Whatever
is,
may be.
no, he will use this order, enter my property and take possession. That is the
No, suppose if the person who has taken a injunction order,
yes,
property in that Bangalore,
yes,
if you go to that Mysore, saying that this is the property
my lord,
injunction.
one can understand. Yes.
Now, what is that remedy for that person?
My lord, then I will be made to.
No, if somebody has taken that injunction, no, tomorrow, if your argument is accepted, I take an injunction in that Indranagar, I go to that some other place, then say that no injunction. If you give an injunction for entire Bangalore city.
No. My lord can say, my lord, as per the layout plan, wherever the thing is.
Injunction is granted in respect of the suit scheduled property.
Yes.
If any person's taking that beyond the suit scheduled property, it is violation of the court order. My lord, you go and establish that. But you are admitting that the suit scheduled properties is not your property. It is enough.
No.
They are saying that this is suit scheduled property. You are interfering. If you are not interfering, don't come to that. If you go to that other land, then you know that how to protect.
My lord, if that is so, my lord, at least I would just take this honorable court. I will not interfere. If he wants an order, yes, my lord. But my lord, only one submission is the possession of mine on 12/1 may not be. That's all.
No, see, no,
my lord,
see,
in the
wait,
guise
wait,
of
wait.
that, my lord,
I will
I
answer you.
Yes.
If anybody is illegally interfering, law has made for an approach to court for injunction.
My lord, I'll have to run the law.
In this suit, you are seeking for an injunction.
Next he will go with police help, try to forcefully get
No,
into
we
the
are not
property.
concerned that
No.
whether
My lord, if somebody comes and says,
law is for chief minister is also same. Law is for the ordinary man is same. For the court is concerned, we have to protect that interest of the court. We are not
no,
concerned.
my
with
lord,
that
it is
court.
like this. It is like this. In the guise
When
of
you yourself is admitting that this is not the suit property, it belongs to you, then you are
my lord, I would have no grievance if as per this plan.
If you accept your contention, powerful man can take an injunction to one property and he can go to that any other property. Do you mean that there is no law and order in this country?
What is happening here is that
if you are there is a chances of misusing, but you know that how to protect your property.
my lord, I will have to understand why should I?
You have to file a suit for injunction your property.
My lord, my suit for injunction preventing, my lord, is there. My lord.
Otherwise, you see that entire in that area, who are all there in that area, they are all before me and saying that, see that, don't interfere. Without going to the civil court, you have to get an order from me. Because this man is taking that interim order and coming to my land also. Then I have to grant, is it permissible? The property which is not the true property, can I exercise that power?
My lord, can my lord
go and file in a suit?
My lord, my one submission. My lord, may kindly see the plain.
Yes.
What does he say in the plain?
There in the plain. In IA.
My lord, no, my lord. I have produced the plain at page 29.
Yes.
The paragraph 2, page 13.
Yes. See, Mr. Counsel, it is simple. You go and file a suit for injunction.
Yes.
You will mention your boundary.
Yes.
He can't come say that, no, it is my property, because his suited property is different.
Yes.
Court automatically grant an injunction.
What grant what is that? I'm not on that, my lord. My submission is he under the guise that 12.
No, I understood that. He may taking that order and coming to your land.
Yes.
Can I do it, grant an injunction? Then nobody will go to that.
My lord, in such case, okay, my lord, my submission is mine. I will try to make an endeavor. Admittedly, the third transaction, right from the first time, 2003, no houses have been built, no kata in their name. They don't have kata. PDA has clearly written not to give kata.
No, that is
no. Then, my lord, there is no building. No, my lord, when it's a vacant site. My lord, when it's a vacant site, my lord, status quo should be on.
If it is not your property, why do you worry? PDI is there, law is there.
No, what I'm trying to
protect your property.
What I'm trying to tell is that when it's a vacant land, my lord is aware, status quo should be built.
No, that's
not an injunction.
No, that is true. If both are fighting for in the same land, then I will decide whoever right is there, whoever is the position. Therefore, I thought that you both are disputing same land. Therefore, I asked them to give an kata center. Now you are admitting that your property is different, his property. No question of that.
No, my submission is that he says that it isn't my land. That it is not in my land is what I'm saying. My lord, I will not say for that. Let him say where, in which survey number his land is. I will keep quiet.
No.
At least that.
Unni Krishnan, he has obtained that injunction in respect of one ABCD suit scheduled property.
Yes.
He has to protect that. If anybody is interfering, if you go to the police, he has to show which is your land and that. You go and get an injunction for your property. If somebody is interfering, you can file a contempt. So suppose if you taken any injunction in respect of that scheduled property which is not there, then he is become in process. He cannot seek for an implementation. If
But-
you come to your land, you go and take an injunction.
Yes, my lord. But my lord, yes, I will not say anything further. I will go to the order of the honorable court. But my lord, let him at least say where, in which survey number, as per the.
Why?
My lord, this honorable court may say that, my lord. Because my lord, he has produced it now.
No, suppose.
His argument last date of hearing was that.
If your argument is that, see, the suit schedule which is mentioned is the property which belongs to you, then I could have different method to find out. Now it is different. Otherwise, I can ask that commissioner or do it all. Now it is an entire different. Your property is different. Why do you want that?
My case before the trial court is that the site which is claiming is my property.
No.
It is only after yesterday.
I told you that you forget about.
Kindly see my.
No, Mr. Unikrishnan, you forget about that survey number.
Yes.
Now that injunction will be granted to that boundary.
Yes.
Always boundaries will prevail against the survey number. He can give a survey number 100. Injunction is granted to that boundary, or that any police or any surveyor go to that, see that boundary to measuring that. That boundary is not your boundary. Why do you worry? Nimma boundary, our boundary tally ಆಗ್ತಾ ಇದ್ರೆ, then I have to ask who are in that possession to relevant document.
ಯಾಕೆ ಫೈಲ್ ಮಾಡ್ತಾ ಇಲ್ಲ? There's a reason why they are not filing this. It's so habit at that point of time, they had not acquired their survey. So called 12/1, what they are saying. At that point of time, the suit was filed by the owners against the society, Judicial Employees Society. There, interestingly, in the compromise petition, kindly see page 55. In the compromise petition, they said we will give up this entire survey number to the society. We will take about 10 sites elsewhere, 11 sites elsewhere.
You have given that 10 sites.
All the 11 sites have been given. The sites that were allotted to this Venktamma is 854.
No, what they are doing in that site, they have found that or sold it.
They have sold it.
We don't know.
That is there. Evidence. Document is there.
Right.
Now they have.
No, now I am not concerned. All these things. Why here? It is only a simple bare injunction suit.
Yes.
Yes, you. That your boundaries is still protecting, go and file in a suit. We'll have it after 2 weeks.
Yes.
You do it that way. This. Yes.
Suppose I'm out.
ಆಯ್ತು ಅವ್ರು ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಇಟ್ ಇಸ್ ಇಂಜಂಕ್ಷನ್ ಇಸ್ ಯುವರ್
ಅಲ್ಲ ಅಲ್ಲೊಂದು ತೋರಿಸ್ಬಿಡ್ತೀನಿ.
ಅವ್ರದ್ದು ಅಲ್ಲಿ ಇಫ್ ಯು ಗೆಟ್ ದಟ್ ಇಂಜಂಕ್ಷನ್ ಇನ್ ದಟ್ ದೆನ್ ಇಟ್ ಬಿಕಮ್ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್.
ಅಲ್ಲ before that their status of the civil right, kindly see not page 61. Kindly see page 58 for a moment, because Leonard Friend went through a maze of facts.
Yes.
58 this is a suit by the same Venktamma who is plaintiff number 4.
Yes.
58, right?
58 is that compromise petition.
Compromise petition alli. Plaintiff number 4 is Venktamma. The same Venktamma who is here.
ವೆಂಕಮ್ಮನ ಹೆಸರು ಇಲ್ಲಿಲ್ಲಲ್ಲ.
ಇದೆ plaintiff 4, P4.
P4 ವೆಂಕಮ್ಮ.
ಮುನಿತಾಯಮ್ಮ, ರಾಧಮ್ಮ, ಚಿನ್ನಮ್ಮ, ವೆಂಕಟಮ್ಮ. Now, in this compromise, what happened? Kindly see paragraph number 6.
Yes.
Both the parties further submit that second defendant has relinquished its rights.
Yes.
In respect to the below mentioned sites found in the allowed by it, in favor of the plaintiffs, and plaintiffs shall be the absolute owners.
Yes.
Now, Lord, kindly see above that, para 4. Plaintiffs withdraw all the allegations in the plaint and agree and accept that second defendant is the owner in possession of a scheduled property.
No, that.
Now,
no, there. See, there is some discrepancy in that survey number. Now they are taking that advantage. The reason is,
yes,
the moment they have started arguments that this compromise degree is not registered. When they are going to the technicality.
Registration Act says.
No, technicality is because
registration. No,
I am not going on all
those issues. Now, one 61 those.
Yes.
61. Para 7. A schedule on sorry. Right side 62 A schedule. All that piece and parcel of land bearing survey number 12/1 measuring 1 acre 26 kuntas, including 0.04 kuntas of Karab situated at Allal Chandra.
Yes.
GVK post. The entire survey number 12/1 is incorporated here. Now, what is the coverage they make against this is? Kindly see para 7 on the left side. Same para 7.
Yes.
Plaintiffs have agreed and undertaken not to interfere with the defendant's peaceful possession and enjoyment of a scheduled property. of this compromise petition. And second, it will not interfere with plaintiff's peaceful possession in the enjoyment of pre-scheduled sites. So why they are not filing the suit is, this will operate as res judicata against them.
Yes.
And they cannot institute a suit because they already have said that they will not interfere.
See, this may not be transfer the right, but regarding protecting the possession, this itself is enough because you have undertaken that.
My lord, yes, my lord,
Yes.
yes, let us assume that, my lord. Then that means he is admitting it in 12/1.
I'm not admitting. If it is his
That
case,
protection
then
will
it
come
is
only for
12/1.
12/1, not
If it is
for
his
that.
case.
Parallel.
Yes.
So even against 12/1, he has no right to touch.
Yes.
And my lord, there is
Now,
a sale deed executed by him.
different tangent.
Now, there is a sale deed executed by him in respect of 854, which is allotted to victim.
Now you can address this argument when he filed in a suit.
Yes.
In that you can address.
There he can.
Yes. Yes. Is this matter of this?
Obliged.
Yes.
Federal company challenging liability, my lord.
Yes.
Passenger carried in goods vehicle.
Why?
Tractor and trailer, my lord.
Tractor and trailer.
Seating capacity only one is traveling in trailer.
Yes. Third issue notice. They have judgment and award dated 12 July 2023, passed by MECT Madhgiri now. MECT Madhgiri in MEC 952 of 2019. The condition deposit of 50% of the award amount before the tribunal within 4 weeks.
I will deposit before this court, my lord.
This court.
Please, my lord.
Sitaram Rao.
Yes. Complaint, my lord. Insurance company challenging quantum, my lord. We have a
Quantum, only quantum.
please, my lord. He's continuing same job after accident. Also, he's continuing same job.
Yes, hard issue notice. They have judgment and degree. Award dated 12th August 2023. Passed by MACP Mudgere in MEC 6 of 2020. The condition deposit of 50% of the award amount with interest before the tribunal.
Please, my lord.
Yes. Why it is final hearing?
There is no respondent. And this is a matter where permission was sought by a trust for mortgaging the property, which was rejected. The application was filed under section 92F.
Yes.
And the petitioner is actually a private trust, but of course it's been declared as a public trust under the Income Tax Act. So therefore, section 92F is attracted.
Yes.
So therefore, we filed an application seeking for permission of the court to mortgage the property. In fact, the property is already mortgaged and loan is subsisting. But since we wanted to renovate, it's a school. The trust is running a school called as Sudarshan Vidya Mandir in Jainagar 4T block. There is some leakages in the bathroom and other places. So we wanted to refurbish that and renew that one. So we approached the bank. The bank said, since you have already taken loan and you have not taken permission from the court, since it's a public trust declared before the income tax authorities, you better take another permission for our clearance. So we approached this honorable lower court, and then we made an application to seeking permission. The court rejected, saying that we have not furnished the plan. In fact, it's a subsisting loan.
Where is that finding?
There at page 6, the order.
Yes.
As per the arguments of the petition, the scheduled properties are the properties belonging to the trust. The petitioner has not come up with the value of these properties as on the date of the petition and necessitating the mortgaging of all the properties for availing the loan as prayed in the petition. Thereby, it becomes clear that the petitioner has not come up with the necessary basic details as to the assets petitioner trust, their proposed plan for renovation or repair of their buildings, approximate cost of such work, the details of such assets and liabilities of the petitioner trust as on this day, and governing body of the petition trust having taken a considered decision regarding need of raising loan by mortgaging the properties of the trust with the reference to the proposed work. In the above circumstances, this court holds the petitioner has not made out a valid ground to allow the petition according. So it's been rejected. Now my respective submission is this. There is already an existing loan.
No, but that is not the contention, averment in the play.
No, it is there. What my submission is, we are seeking only for repair and then refurbishing that one. For that, there is no question of any obtaining of the plan. Plan will not be granted. And that is one aspect. Now, the second aspect, which is a legal submission which I am making, this is a petition in the nature of a summary proceeding, wherein notice was ordered by way of a paper publication inviting any objections from the general public. We have taken out paper publication. None of the anyone has opposed it. There was no objection in any quarter whatsoever. Now the question is, if the nature of the court below had to inquire whether it is required or not. Now it is kindly appreciate this fact. This is only an inquiry, not an evidence. Your Lordship is aware, evidence is a totally different concept and inquiry is a totally different concept. Inquiry is the court will ask the party, yes, what is it? It is a question and answer kind of a thing. It is not I who come and then come out.
Prima facie has
Yes, prima facie, it's all been done. I have produced all the documents. In fact, 14 documents have been furnished. And even otherwise, records have also come, I think.
From where records has to come?
Records bandilwa.
Records bandilwa. Ellinda barbekidu?
Lower court.
Bangalore.
Yes, Bangalore.
Bangalore only.
Bangalore. This is a very reputed school, Sudarshan Vidya Mandir and Jainur Court Diploma. My submission is, if the court felt that there is some evidence that requires to be produced, nothing prevented the court from summoning the documents. Order 16 Rule 14.
That will secure the records and see if sufficient records has come, it is in the branch.
And it's an innocuous application because the trust itself is a private trust where 92 is not at all applicable. But the petitioner has, the appellant has approached the income tax and declared themselves as a private. So certificate is.
What are the documents you have produced?
I have produced that your lordships will get the list of documents, page 20, ink page 20, page 8 of the order.
No, that in that records page.
Petition, appeal memo list of documents I would read out. List of trustees and directors, supplementary trustee dated so and so, supplementary trustee dated 24/12/91, supplementary trustee, certified copies of trustee, modified trustee, and all the trustees. And exhibit P8 is a certificate before these the income tax authority declaring that we are a public trust. That is why I am under 92. And copy of the board resolution where the resolution was passed saying that
relaying that this thing.
Yes.
Regarding that loan and all, what is the document you have put?
No, I have not.
Certified
I have
copies
not.
of the gift deed. What is that gift deed?
These are the documents where the ownership of the trust to show that the trust is the owner. And of course, we have already all these documents are all mortgaged to the bank and deposited.
You have to prima facie shows that now you require this property has to be mortgaged for renewal.
It's already mortgaged. It's already mortgaged, an extension of mortgage. In fact, if my submission is in, there was no requirement of another permission because there are already a permission.
No, that mortgage has been done before taking a permission.
No, after permission itself. Earlier we have taken permission from the same court.
There was an order.
Yes.
Then where is that order earlier?
I made a statement. I can produce it if your lordship permits
in
me.
that records?
No, it is not there. I can produce that one.
No, if
that is my submission. If the court
if that is there, then all this requirement has covered earlier.
That is my submission, and it's an innocuous thing. No one has objected also.
No. We have to see whether it is true or
absolutely. Not. For that, order 16 roll 14 comes into play. That is my legal submission.
What
If
is
the
that?
court is inquiring that yes, as a court, I feel that there is something has to be done. I have to look
No,
into
no,
certain
see,
documents. No,
yes,
there
no,
are
that
judgments.
is required.
The court
No, when
can-
already granted in respect of the very same
Please.
relief, then court has to see that earlier order, and that is what
I
the
can produce that one if your lordship gives me some time.
230.
I'll file along with
Yes.
today is Agala.
Yavat better. If we produce, then I can dispose of
Absolutely.
any date on, we can produce on 18th,
18th better. 17th October.
17th.
18th I have some personal income.
Yes,
That's my
17th.
anniversary. That's why.
Yes.
I promised my wife that I'll just.
Yes. We'll have some. Yes. 17th.
17th.
Yes. You produce that, then it is easy for me to also dispose of it.
Obliged. Even otherwise, there are some decisions which says the court has got jurisdiction to call for documents. If it is not exercised, then it is not.
Now that again it is one more, I have to remand and ask you
They
to
are not
produce.
required.
Instead that if you produce and satisfied me, I can, otherwise I can send it back and ask you to produce before the trial court.
Yes, it that can be disposed of here itself.
Will dispose of on that your submission and give, you may be permitted to produce before the trial court.
Please, I'll do that.
His appeal is filed by petitioner.
May I, sir? I'll produce it next date of hearing.
That's what I said.
Your lordship may pass orders on that day.
No, that is, I said, I can close your case here itself.
No, not required.
Other,
ತಮ್ಮ ಮುಂದೆ ಮಾಡ್ಕೊಳ್ಳೋಣ.
ಅಲ್ಲ ಅದಕ್ಕೆ ನೀವಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ I have to again send it back, permitted you to produce. Therefore I said you produce here.
Yes, I will produce it. 17th.
You said it can be disposed of here. Therefore I said.
No. I'm sorry. I may have not been clear about it. My submission was I'll produce it here and your lordship.
Yes. 17th. Yes.
May I take leave?
Yes.
Another matter is-
Yes, you can. ಬಂದಿಲ್ಲ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
Serial number 8, this one is JR.
That's only. Then that, which is the judgment, Mr. Raghu?
Shriram General Insurance. The other is may not relying on that. Our honorable division bench.
What is that judgment?
But your lords may kindly second page. Para number 3. The notice in terms of order dated 31/10/2000 was confined only to aspects. The sum for loss of love and affection being 50,000 and for loss of consortium 40,000 could not have been granted to each of the 3 dependents separately, but in total, and that would be the amount quantified. This was in terms of judgment of National Insurance Company. This case, we have heard the learned counsel for the party. Learned counsel for the respondent did endeavor to persuade us that it should be per the legal here by relying on Magma General Insurance Company Limited case. We are, however, of the view that the total amount has to be assigned under a particular heading, and that will go depending on the number of legal heirs present. The amount fixed in terms of Pranay Sethi case are rupees 50,000 and rupees 40,000 respectively under the 2 heads, and the same should be total amount payable. Having said so, the learned counsel for the respondent point out that this amount so determined by us is able to be enhanced by a percentage of 10% every 3 years, as applied in para 61 of the judgment. Variable figure on conventional acts, namely loss of estate, loss of consortium, funeral expense should be 15,000, 40,000, 15,000 respectively. The aforesaid amount should be enhanced at a rate of 10% in every year. Every 3 years. The aforesaid question is not disputed by the learned counsel for the apparatus. Thus, this calculation on account of interest would also be admissible for the benefit of the respondent from the date of the award, which will mean in the present case there will be 2 escalations, 10%.
Then law like that, but facts.
ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್
ನಾನು ನೋಡಿದೆ ಅದನ್ನು ನೋಡಿ ಎರಡನ್ನೂ I know that you have got it. ಅದರಲ್ಲೂ ಕೂಡ it has been said. They said ಇದೆ ತಾನೆ.
ಹೌದು.
Yes, I have it. Therefore, I ask you to come and explain.
Our humble submission is that.
See, you see that Magma case.
Correct.
Court has laid down the law. That has not been reversed by anything. This thing.
In length, my lord, it has been
nothing is not applicable to it. There is no law has been laid down. The judgment has not been overruled. I see, when there is a Supreme Court judgment on that law, we can't go against that. But I have verified and see here, 40,000 and 50,000, love and affection and consortium, both has been granted. That cannot be. They said, increase 10%, that is all law. After seeing that, I said, I am not convinced so far.
Our effort is only this.
No, I have seen that. But if there is a Supreme Court judgment, we can't go against that. But on the other hand, Supreme Court has explained in that. Therefore, I have also searched any other judgment has come, because my judgment should not be contrary. But I have not get any judgment at all.
Humble submission. See, my lord, your lords may kindly appreciate the question raised is very clear about the loss of consortium. Then, my lord, the Supreme Court referred to my lord, Magma General Insurance Company. Recognize this case. Recognize this case, my lord, it's a fine
No, what that subsequently Magma has explained.
Yes, sir.
Pranay Sethi said consortium. What is the meaning of consortium? They explained. They are expanded it, but it is not High Court. Supreme Court has expanded it. Then you are also agreeing, you are also granting and all. That has not been straight away distinguished or reversed. And also see that love and affection 50,000, consortium 40,000, Bora Prasna illa. Then Pranay Sethi 50,000 and 40,000 respectively, 2 heads. Only the 50-40. No, you see that para 6 amount fixed in terms of the Pranay Sethi.
In the para 6,
having learned counsel has pointed out the amount so determined by that use is liable to be enhanced by percentage of 10% trustee. See, ಪ್ರಣಯ ಸೇತಿ ಪ್ರಕಾರ 50-40 ಮಾಡಿದ್ದಾರೆ ಅಂತ 6ರಲ್ಲಿ ಹೇಳಿದ್ರು. 7ರಲ್ಲಿ 6% ಎನ್ಹಾನ್ಸ್ ಮಾಡ್ಬೇಕಂದ್ರು. 6% ಎನ್ಹಾನ್ಸ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ರು. ಅಷ್ಟು ಬಿಟ್ರೆ ನಮಗೆ ಪ್ರಣಯ ಸೇತಿ ಕನ್ಫ್ಯೂಷನ್ ಬೇಡ. ನೆಕ್ಸ್ಟ್ ಯು ಕಮ್ ಟು ದಟ್ ಮ್ಯಾಗ್ಮಾ. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಮ್ಯಾಗ್ಮಾ ಸೆಡ್ ವಾಟ್ ಪ್ರಣಯ ಸೇತಿ ಸೆಡ್ ಇಸ್ ದಿಸ್ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ನೋ 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 ಅಂತ ಐ ಕಾಂಟ್ ಸೇ ದಟ್. ಆಮೇಲೆ ಅದ್ರಲ್ಲಿ ಗ್ರಾಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. They can say in any cases, unless the judgment has been overruled, it's binding on that. It's facts of that. If any other case distinguishing that, in terms of that constitution bench, that magma is not correct, this is correct ಅಂತ ಹೇಳಿದ್ರೆ, then we can straight away. ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ಮ್ಯಾಗ್ಮಾನ 2 ಜಡ್ಜ್ ಡಿಫರೆಂಟ್ ಮಾಡಬಹುದು. ಯಾಕೆಂತಂದ್ರೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಬೆಂಚ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ರೆಫರೆನ್ಸ್ ಏನು ಬರದೇ ಇಲ್ಲ ಅಲ್ಲಿ. ಬಟ್ ಯಾರು ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ. So far, let us see. ಲೋಕಾಯುಕ್ತದಲ್ಲಿ ಎಷ್ಟು ಮಾಡ್ತಿದ್ದಾರೆ? ಅವರು ಅದ್ರಲ್ಲಿ ಏನು ಸುಮ್ಮನೆ ನೋಡ್ದೆ ನಾನು ರಿಲೈಂಗ್ ಅನ್ಬಿಟ್ಟು ಹೌ ಅಂತಾನೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿಲ್ಲ. ಇದನ್ನ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ನೀವು ಹೇಳಿದ ತಕ್ಷಣ ನಾನೇ ಹುಡುಕ್ಸಿ ನಂಬರ್ ಎಲ್ಲ ತೆಗ್ಸಿ ಎಲ್ಲಿ ಅಂತ ನೋಡಿ ಆ ಸೀನ್ ಇಲ್ಲೇನ್ ಹೇಳ್ತಾರೆ ನೋಡಿ. The tribunal has awarded towards the medical expenses. Hence, same is been awarded. The tribunal has awarded 1,60,000 loss of transaction, 45,000 towards the loss of estate. That amount appears to be excessive and not in accordance with law laid down by Honorable Supreme Court. So, excessive ಅಂತ ಹೇಳಿದ್ರು. Yes. Sriram General Insurance Company, that amount has to be recalculated, therefore it is to be recalculated. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಶ್ರೀರಾಮ್ ಇದರಲ್ಲಿ ಯಾವ ತರ ರೀಕ್ಯಾಲ್ಕುಲೇಟೆಡ್ ಮಾಡಬೇಕು? No, she cannot accept what that our client says. We are that law, what it says, you have to convince your party and assist the court. ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ. ಆಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು ಬಾಕಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆನ್ ಲೆಂತ್ ಬೈ ಲಾ ದೇ ಹ್ಯಾವ್ ಡಿಸೈಡೆಡ್. This is not law decided. We cannot apply that. ಆಯ್ತು, ಅದೊಂದು ಬಿಡಿ. That will see that after 2 weeks. Other 2 matters will decide. ಕೊಡಿ ಇಂಜುರಿ ಕೇಸ್ ಕೊಡಿ. ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್. ಇಂಜುರಿ ಕೇಸ್ ಯಾವ್ದಾದ್ರು? ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟಿದ್ರು? No, that MEC 428. 428 ಇದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಯಾರು? ಪೇಜ್ 25. Page 24. MEC 428. 36 24. ಎಷ್ಟು?
1,65,000
ಏನು ಇಂಜುರಿ ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು ಮಾಡಿದ್ದಾರೆ.
ಎಷ್ಟು ಡಿಸಬಿಲಿಟಿ ಹೇಳಿದ್ದಾರೆ?
ಡಾಕ್ಟರ್ ವಿಶಾಲ್ CW1.
ಇಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಎಲ್ಲಿದ್ದಾರೆ ಡಿ ಅಲ್ಲಿ ನಿಶಾಂತ್ so and so as per the ನಿಶಾಂತ್ 22% lower limit disability is interfering with
Gravity of that
examination disability certificate.
Right lower limb and liability is interfering with the day-to-day activity.
ಏನ್ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ
ಗೊತ್ತಿಲ್ಲ ಸರ್
22% ರೈಟ್ ಲೋಯರ್ ಲಿಂಬ್ ಅಂತ ಅಂದ್ರೆ 1/3 ಎಷ್ಟು ಬಂತು
8%.
8%. What is that income?
Income is that is 13,000 is 10,000 per month. He was working as a cook in St. John's School.
What is that year of accident?
Year of 2015 you will ask.
15 ಗೆ ಎಷ್ಟಿದೆ
9,000 ಇದೆ.
9,000. What is the age?
38 years.
38 years. Multiplier
by 50.
ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ
11 days and following the treatment.
11 days. Loss of immunities, food and attendance. Will reassess by giving 8% disability. What about that other case?
And the immunities is on wire and pain and suffering is wire.
That will consider.
Another one is our Umesh, that is 423.
Page
that is
22.
Only 1,50,000 paid.
423. ಏನಿದೆ ಡಿಸಬಿಲಿಟಿ ಏನಿದೆ
Suffering from permanent disability is not able to do work.
ಡಾಕ್ಟರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ
Doctor ಇವ್ರ ಬಗ್ಗೆ
ಡಾಕ್ಟರ್ ನಿಶಾಂತ್ ಲಾಸ್ of sensation over the skin grafting
11% ಹೇಳಿದ್ರು ಸ್ವಾಮಿ according to the
suffering 11% permanent disability impaired to the right upper limb 11% ಅಂತ ಅಂದ್ರೆ 3% 4% ಬರ್ತದ
4%. In amenities pain and suffering is on wire side.
Hospital
20,000 ಕೊಟ್ಟಿದ್ದಾರೆ, conveyance 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ,
ಹಾಸ್ಪಿಟಲ್
food and attendance 10,000, income of 2 months ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ದಿನ ಇದ್ರಿ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ
More than 8 days. Then following the treatment.
Interest ಅವಾರ್ಡ್ ಮಾಡಿ
Income that is
interest 6%.
interest.
We'll do it that is 8% and this is 4%. Yes, Mr. Redda. So first 422 na 423 ಯಾವ್ದಕ್ಕೆ MFA
423 R Umesh, MFA that is 1813,
1812 MFA 1812 of 2020 arising out of MEC 423. Senate Council for the Climate has contended that to that extent climate has suffered grievous injury. He was inpatient for a period of 8 days. He has examined the doctor PW2. In his evidence, he has deposed that climate has suffered 11% physical disability to right upper limb. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side, which is sought for enhancement of compensation. For contrast, secondly, he has contended that at the time of the accident, claimant was earning 10,000 per month. Then assess ಮಾಡಿದ NCC. For contrast, the Hegde Learned Council appearing for insurance company has contended that the injuries suffered by the claimant are minor in nature. He was inpatient only for a period of 8 days. The disabilities assessed by the doctor is 11% to right upper limb. It will not come in the way of the claimant to do his day-to-day work. Therefore, the overall compensation awarded by the tribunal is just and reasonable. And she sought for Dismissal of the appeal. Heard the learned counsel for the parties. Heroes. Judgment and award. Not in dispute. Claimant has suffered an injury. The road traffic accident occurred on 26/10/2015 due to rash and negligent driving of driver of lorry bearing registration number GA01 T7744. Due to the accident, claimant has suffered the following injury. He has examined the doctor as PW2 as CW1
CW1
as CW1. His evidence, he has deposed that claimant has suffered 11% permanent physical impairment in his right upper leg. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the whole body disability has to be assessed 4%. Even though claimant has claimed that he was earning 10,000 per month, he has not produced any document to establish the same. Personal income has to be assessed as per the guidelines for the accident occurring 2015. The notional income has to be considered as 9,000. What is his age, Mr.?
That is 38 years at the time of accident. He is working good.
Generally, 423.
423.
423. What is his age?
That is age 423.
Let me see 423 of 2016. Three on age is he was
35 years.
35 years.
35 years.
The multiplier applicable to that age group? 16. Accordingly, loss of future earning has been reassessed as per. Due to the accident, claimant has suffered the above said injury. He was inpatient for a period of 8 days. He has suffered lot of pain during the treatment. He has to suffer the disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, declined to enhance the compensation for pain and suffering from 20,000 to 30,000. Loss of immunities kotilva. Loss of immunities to 25,000. The claimant is also entitled for loss of immunities 25,000. Loss of income during the later period has to be granted for 2 months. Everything will put it there.
10,000.
Other than everything law, yes. The compensation awarded by the tribunal in the other hand are just and reasonable. And naturally, contention same. 4/8 of 2016 MEC. Heard the learned counsel for the parties. Due to that accident, the claimant has suffered the following injury. He has examined Dr. Nishan as CW na idrallo other nanu
8 years age. 22% right to
already doctor examine has been examined as CW1. In his evidence, he has deposed that the claimant has suffered 22% disability in her right lower limb. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 8%. Even though claimant has claimed that he was earning 10,000 per month, he has not produced any documents to establish the same. The circumstances, notional income has to be assessed as per the guidelines issued by Legal Service Authority. For the accident occurring in 2015, notional income has to be assessed as 9,000. At the time of the accident, he was aged about 38 years. The multiplier applicable to the age group is 15. Thirdly, loss of future earning has been reassessed as follows. Yes. Due to that accident, the claimant has suffered the following injuries. He was inpatient for a period of 11 days. He has suffered a lot of pain during the treatment. He has to suffer the disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 40,000. Loss of immunity is 30,000 to 40,000. The claimant is also entitled for loss of income during the later period for 2 months. Compensation awarded by the tribunal in the other hand are just and reasonable. Partly, the appeals are allowed in parts. So, MFA 8113 of 2020. The request used this matter of previous.
5.2 federal 4 days delay.
Yes, delay in filing that appeal is controlled.
8.2 yes, what is that?
Yeah, 214 memo could dispense. What is 214 is dispense. That case, you want to canvas on that argument on that this thing. After ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅಲ್ಲ 5 ಜನ ಯಾರ್ಯಾರು ಅದ್ರಲ್ಲಿ ಕನ್ಸಾರ್ಷಿಯಮ್ ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ ಗೆ ಮ್ಯಾರಿಡ್ ಏಜ್ ಬರಲ್ಲ. ದರ್ ಆಲ್ ಎಂಟೈಟಲ್. ವಾಟ್ ಈಸ್ ಇಸ್ ಏಜ್?
But loss of future perspective ಬರಲ್ಲ, only for income taken.
ಮಾಡಿದ್ವು ಅವಾಗಲ್ಲ.
ಹೌದು ಚಂದ್ರ. 5,000.
So and so learned council appearing for income 5,000 ತಾಂಡಿದ್ದಾರೆ. ಅವ್ರನ್ನು ಕ್ಲಬ್ ಮಾಡ್ಬಿಡಿ ಅವರು ಫ್ಯಾಕ್ಟ್ಸ್ ಉಂಟೆ. ಅದೇ income cannot be enhanced because this claim itself is 5,000. Yes, learned council appearing for the claimant has contended that $5,000 to future prospect ಇದನ್ನ ತಾಂಡಿದ್ದಾರೆ. ಎಲ್ಲಿದೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್? 386 ಎಲ್ಲಿದೆ?
Page number 24 your lord. Paragraph 17 of the internal page.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Only 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾಕಾಗಿ?
Only for conventional rate ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. Not calculate.
So and so learned council appearing for the claimant has contended that the time of the accident it was earning 5,000 per month. The claimants are entirely depending upon the income of the deceased. The tribunal has failed to grant any compensation for loss of dependence. The contended that in view of judgment of apex court in case of Karnataka, claimants are entitled 15,000 for loss of estate, 50,000 for funeral expenses. And view of judgment of apex court in case of magma, claimants are entitled 40,000 each. It is sought for enhancement of contra. Sri Hegde Learned Council appearing for insurance company has contended that at the time of the accident, deceased was aged about 65 years. The claimants are major sons and married daughter. They are not depending upon the income of the deceased. Therefore, the tribunal has rightly granted a compensation of rupees 50,000. The other contended that since the claimants are major son and married daughter, they are also not entitled for any compensation under the head of love and affection or consortium. ಯಾವ judgment consider ಮಾಡಿದಾರ? The trial court rightly consider the judgment of Manjuri Bera versus Oriental Insurance Company and granted a compensation of rupees 50,000. There is no error in or passed by the trial court. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. What is the name of the deceased?
Ansuya Bai.
Ansuya Bai died in road traffic accident occurred on 26/10/2015 due to rash and negligent driving of driver of tempo bearing registration number KA14 A7829. At the time of the accident, deceased was earning 5,000 per month as a helper at Shantini Ketana Charitable Society, Kadikoppa, Shimoga. Considering that evidence of PW1, the monthly income of the deceased has to be considered as 5,000 per month. At the time of the accident, deceased was aged about 65 years. The multiplier applicable to that age group is 7. Since the claimants are major sons and married daughter, 50% of the income of the deceased has to be deducted for personal expenses. Accordingly, loss of dependency has been reassessed as follows. 5,000 minus 2,500, 2,500, 2,500, 2,10,000. In addition, in view of judgment of apex court in case of Pranay 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, the first claimant error.
First claimant is the son.
Second, the claimants are sons and daughter of the deceased. Hence, they are entitled 40,000 each for parental consortium. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit compensation amount with 6% interest. Subjection.
Subjection. Why respondent number 2 made as party in this appeal? Respondent 2 is deleted before trial court.
appear for the appellant, raise this matter of course.